Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbus Latinos.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addicts. Happy Friday afternoon to you as we are working towards the weekend and rapidly approaching. A big shout out to Kim R, who's first in chat today. Kim, congratulations. Everything up here they did worldwide is your responsibility. That's the punishment you receive for being prompt, being first in chat today. Congratulations. Alrighty. Welcome. 53 degrees and raining in Montana. May consider turning on the fireplace. Oh man, that's pretty bad. That's pretty bad. I've got the AC going here, but I have no idea how warm it is outside. Let's see. This one. We're trying to get a little case ready for you.
Daily,
Oops.
or a
Hang on. I think it's this one. We're going up to Thurston County, Washington to watch some civil stuff today, is what we have in mind. So let me see if this is it.
6. Understand that parties have been to mediation, and mediation has been unsuccessful. Is that correct?
Let's back up and hear who these parties are.
Okay. All right. So number 1. This is Carl Jacobs and Selena McCabe Gould. It's case number 39436. Understand that parties have been to mediation, and mediation has been unsuccessful. Is that correct? Jacobs? Yes.
That is correct. We actually had mediation at our previous hearing back in March or April, in which we agreed to a settlement, but I signed, the defendant did not sign, so I had to refile, and that's why we're back. We did just try mediation again and did not come to an agreement.
All right. Case number 39436. We'll begin this trial right now. Mr. Jacobs, tell me about what you believe you're owed in this matter.
And to get out of his way.
I'm simply asking for rent that was not paid after Selena moved out, broke a lease and moved out early. I've calculated the rent just specifically right down to the day when we found another tenant to move in and sign a new lease. So I'm only asking for the rent owed through that day. The lease actually, Selena's lease actually went a little longer, but I'm always willing to work with folks to find other tenants when people are coming and going, and provided both copies of both of those leases. So that's, I guess in a nutshell, that's all I'm asking is for rent not paid.
The amount you're asking for?
$875.
All right. That's based on a daily, or a calculation of monthly rent divided by 30 days or whatever it is. Come up with the daily rate times the number of days, right?
Correct.
All right. Ms. McCabe, what do you want to tell me? You're muted, Ms. McCabe. We can't hear
Sorry
you.
about that. Thank you for allowing me to speak.
I'm respectfully asking that the court deny or reduce the amount that the landlord is seeking because I believe I acted in reasonable faith throughout my tenancy, and the amount claimed does not fairly account for the circumstances. I signed the lease in October 2024, intending to complete it. I had no intention of moving early. About a month after moving in, the living situation with the roommates deteriorated significantly. There were repeated verbal confrontations, hostility, and behavior that made me feel unsafe and unwelcome in my own home.
That's not the landlord's fault, though.
Because I had 2 young children living with me, I often chose to stay with friends or family rather than expose them to the conflict. Even though I was paying rent, there were many nights and weekends when I could not comfortably stay in the home. I kept my landlord informed about the problems as they developed. I also participated in mediation with my roommate in an effort to resolve the situation. Unfortunately, those efforts were unsuccessful and the living arrangement continued to worsen. Despite these difficulties, I continued paying my rent on time while I lived there. I also paid the household utilities. I even replaced the washer and dryer when the existing units failed. I tried to be a responsible tenant throughout my tenancy, but eventually I concluded that remaining in the home was not healthy or safe for my children or me. I notified my landlord that I would be moving, left the property clean, surrendered my keys, and even attempted to help find a replacement tenant by posting an advertisement for such a person to arrive. I also forfeited my security deposit. So I understand that breaking a lease can have financial consequences, but I believe I made every reasonable effort to minimize the landlord's losses while also protecting my children's well-being. Considering that I paid rent while I lived there, forfeited my security deposit, left the property in good condition, and the home was re-rented before the lease ended, I respectfully believe I have already borne more than my fair share of the financial burden. For those reasons, again, I ask respectfully that the court move to dismiss the remaining claim that Carl is asking. If the court determines that some amount is legally owed, I ask that any award be limited to the smallest amount the law allows after considering the security deposit, the landlord's efforts to re-rent the property, and all of the circumstances surrounding my early departure.
She's either had help
Thank you
from
so much for your time and consideration.
ChatGPT or a legal friend.
Thank you.
That was well written. But unfortunately, the law's on his side.
Mr. Brooks, talk to me about the security deposit.
Yeah, the security deposit was factored into my calculation of rent owed. So item number 6 are emails between me and Selena. And the one at the very top shows the calculation. The security deposit was applied toward the month of May for the rent owed. So I just kept that for rent owed in May. And then there were 3 weeks in June until a new lease was signed with a new roommate. And so I'm only asking for those 3 weeks that was not covered by the deposit and was not paid.
Ms. McCabe, your response to that?
Yes, my security deposit covered the month of May's rent. I was told that a new tenant filed in sometime in June. I don't know what the proof of their tenancy or costs incurred through the month of June actually look like, other than what Carl claims.
All right, I believe, Mr.
proof.
Jacobs, you filed a copy of the lease that shows that new lease started on June 22nd. Is that right?
That's correct.
So you're saying there was 21 days, June 1 through June 21, where rent was owed. The rent was under the existing lease, $2,500.
Sorry, that was
divided
me
that by
making the
30
slurping noise.
days, come to $83 and some cents per day, times 21 days. That came to $1,750 that was owed under the original lease, the lease, Ms. McCabe, that you were on. And the other party
I had no idea it was going to be a long slurp.
$875. That's half of the amount. And the remaining $875 is what Mr. Jacobs is requesting at this point. Is that right, Mr. Jacobs? Did I do that math right?
Yes, you did. That is correct.
All right. And I'm looking at an email, Ms. McCabe, that was sent on June 29th at 3:49 p.m. It has that calculation in it.
Sympathetic to her cause, not safe environment to raise kids. You want to get out of there. But unfortunately, the contract with her landlord has nothing to do with that. The landlord has no control over her roommate situation unless there's something I don't understand going on.
So, Ms. McCabe, is there anything else that you wish me to know about this?
No, I have done my best to try and mediate the situation, and I've spoken my piece. I am currently at no liberty to budget towards payments to Carl. I'm a single mom, and I'm on 5 different types of public assistance. And that is why I am respectfully requesting for the remaining rent to be dropped or reduced to the lowest minimum by the court, if possible, today, please.
Thank you.
Go.
All right, Ms. McCabe, based upon what you've told me, I understand the situation that you're in. I understand it's probably not a situation
Did you burp?
of your entirely of your making. I understand the situation with your co-tenant in Mr. Jacobs' property deteriorated.
Unless the landlord booked that other co-tenant.
Not assigning any kind of responsibility for who caused that. That's not the issue here. And the fact that that co-tenancy kind of broke down, that's not a reason to breach the lease agreement that would allow the rent to be excused. Mr. Jacobs, as the landlord, as the tenant, landlord of the property, doesn't have any kind of responsibility to ensure that you and your co-tenant have a reasonable working relationship. And then the other part of it is, as I say, although I understand the circumstances that you find yourself in, the court really isn't in a position to adjust the terms of the contract that you signed and lived by for well over a year. So I'm not in a position to say, well, instead of the $83.33 a day that you should have been paying for that property, you should pay something less. That would not be fair to Mr. Jacobs under the circumstances. As a result, then, Ms. McCabe, I am going to find that Mr. Jacobs has met his burden of proof in this case. I am going to award him a judgment in the amount of $875 for the rent that is owed. In this case, I think the only real leeway I have here is in terms of filing fee and service fees. So I'll waive those. I want to add that to the judgment.
That was nice of him to do that.
So the judgment will be entered in the amount of $875
but he
in
needs
favor of Mr. Jacobs.
Well, when he did that, he actually took money from Mr. Jacobs because Mr. Jacobs had to pay the filing and service fees. Mr. Jacobs' phone is either broken or his cat is currently in possession of it. The sippy cup isn't water. I agree. I don't think it is. I think it might be like a milkshake or something. So something thicker.
All right. I've signed that judgment in favor of Mr. Jacobs in the amount of $875. Each of you will be able to get a copy of that from the clerk's office next week. That's all for today. Mr. Jacobs and Ms. McCabe, thank you for being here today. Good luck.
Thanks, Your Honor.
Thank you for your time.
You're welcome. All right. Next is number 4 on the calendar.
This one I've heard has pistachios
Clara
in it.
Diaz and Oscar Hernandez versus Security Self-Storage. This is case number 39502. And this is a claim
Clara's
for
just happy to be here in the bottom right-hand corner.
damages
It's our turn. We're on TV. Hi, Judge.
incurred for items that were stored in a self-store unit. Ms. Diaz, Mr. Hernandez, I'll hear from you first.
Good morning, Your Honor. My name is Clara Diaz, and this is Oscar Hernandez. This case concerns Secure Self-Storage on Cooper Point's failure to warn us about a rat problem, which deprived us of the opportunity to protect our property. I rented a unit there from February 2021 through October of 2023. And on March 12th of 2023, we returned from a cross-country trip and found extensive rat damage. There was urine and feces, chewing, nesting, and staining throughout the entire unit and all over our things. I reported it the next day, so March 13th, to staff, and they had told me that they already knew about the problem. That day, the district manager, Paul Gendry, was on site, and he specifically told me that management had received rat complaints from other tenants for at least 2 to 3 months. So despite that knowledge, they never notified me, and as far as I know, they didn't notify other tenants. Had they warned us, I would have removed our belongings and prevented as much of this damage as I could have. Management did offer us a reduced rental rate and to move to another unit on the same floor. We accepted that temporary assistance because we didn't have an immediate way to relocate a 10 by 10 unit. But I never agreed that this resolved our problems or the property damage. I've calculated what that move and the reduced rental rate came to, and I don't have it off the top of my head, but I believe it was around $200 total. And also, since it came up in the mediation, I did want to mention that we did not store any perishable food or attractants in our storage unit, but the design of the facility allowed the rodents to travel along the rafters, which we witnessed on more than one occasion. In addition, I did maintain rental storage insurance for the entire duration of my tenancy. Oscar and I spent 3 10-hour days documenting, disinfecting, sorting, laundering, and disposing of damaged property. My claim is conservative. I included only property I could document with confidence. I depreciated every item for its age and condition, and then I further reduced the value of anything partially salvageable. The defendant may rely on language in its lease allocating ordinary pest risks, but this case is about management's actual prior knowledge of an ongoing rat infestation and its failure to give tenants a warning that could have prevented the loss. A liability waiver does not protect gross negligence. And so for that reason, I'm requesting $4,148 in documented damage, plus the $50 filing fee and a $73 sheriff's service fee for a total judgment of $4,271.
ChatGPT has made everybody a lawyer. Mediation is no more.
Now, I see three folks who say secure it.
Jeannie.
Self-storage. Ms. Reynolds, are you going to speak on behalf of Secure It Self-Storage?
If there's a rat in the background,
You'll have to unmute yourself to do so.
Yes, Your Honor, I submitted an authorization to represent by email. It should be in the file.
If there's a rat in the background somewhere. Paul's background, back by the chair or something. Maybe he comes out of one of the cupboards behind Jeannie. This magistrate, in stark contrast to what we just saw with Alex Murdaugh earlier today, has not pre-read all the submitted documents.
Actually, the last page of my exhibit packet.
I'm sorry, say that again?
It's the last page in the defendant's exhibit packet.
Jose and Paul are here to support Jeannie. One of them, I think, just might be here for moral support. Maybe it's Jose. So I just found out that...
all right, I see it.
Thank you, Your Honor.
Go ahead.
The Tupac's ashes are just
Your Honor, I'm here today
from...
with the Regional Director, Jose Oliveras, and the Property Manager, Paul Gendry. I'm familiar with the contract. Mr. Gendry was there for conversations and communications with the plaintiff. My exhibit packet is 12 pages. Pages 2 and 3 is the rental agreement. I've highlighted the sentences that I think apply to this claim, which we do not believe is a claim regarding rat infestation. It's a claim regarding a damage to property. Page 2 states that the storage unit may not be used for perishable items. Page 3, again highlighted, responsibility of the occupant is that all items are stored at the occupant's risk. If the occupant wishes to have insurance, they must obtain their own coverage. The owner does not take custody over the contents and does not agree to provide protection for the storage unit or the contents therein. And the occupant agrees to indemnify and hold owner harmless. On page 4 is the house rule sheet that's presented at move-in. Mr. Gendry would have gone over this sheet with the plaintiffs. Again, we stress no food items. Page 5 is a rental increase notice that was mailed out March 3rd of 2023. And on March 13th of 2023, the plaintiff either called or met with Mr. Gendry and notified him of the damage to her property. At that time, he offered relocate, put her in another unit. He waived the rent increase and actually offered a discount. And plaintiff accepted the offer and moved to a new unit about 7 doors away from the unit they were in. We didn't hear anything else, or I'm sorry, the communication log shows no further communication on the vermin issue. I would like to point out this is a month-to-month contract. You can leave at any time. In March, as I said, they accepted unit 23064. That agreement is on pages 7 and 8. It's the same contract. Owner is not responsible. They stayed for 6 months with no communication noted. Mr. Gendry is here to confirm. And defendant is asking that the court gives a full dismissal of the claim with prejudice.
All right, so throw it out or make the storage unit pay $5,000. Those are your options, or somewhere in the middle, Judge.
Let me see if I understand, Ms. Reynolds. On one hand, you're saying there were perishable items included in the storage unit.
Page 11 and 12 of my packet are actual photos from the plaintiff's exhibit packet that shows at least pistachio nuts were in the unit. I don't know of anything else, but there's pistachio nuts opened up and loose all across that rug photo, which indicate to us that there were food items in there, which is attractive to animals.
And they're tasty as well. Defense is like, the plaintiff's like, wait, we put that picture in?
And tell me what you believe the facility responsibility is for rodent control.
We have, and Mr. Oliveras is our regional director, but it's my understanding we have monthly or biweekly service that comes out and sets up bait stations. May I ask Mr. Jose Oliveras to join us?
You may.
Thank you, Your Honor. He's unmuted.
Yes, Your Honor. We do have pest control that comes through twice a month and just does the monthly service.
It's hard to get rats to eat poison when there's pistachios around, though.
And Mr. Oliveras, were you aware, and did you make the pest control service aware that there was a rat infestation?
It's a case-by-case situation. So whenever a tenant says something, we try to do anything we can for that tenant.
So is that a no?
So is that a yes? You made the pest control people aware that there was a rat problem?
Correct.
Correct.
And did they indicate that they would increase their activity?
No.
Put more traps out or do whatever they had to do?
They monitored it a little closer, but it maintained at the two visits a month.
All right.
May I speak, Your Honor?
Yes, go ahead.
I would like to say that I've been presenting for many years. This is the only claim we've ever received. It's a very large facility. We have 8 different facilities, and I'm not clear that it was an infestation as much as an issue. I'm not clear on the details, but we do our best to maintain a quality facility. We did address it when it came up. We felt we addressed it. We didn't hear anything else about it. No other complaints or move-outs or lawsuits had come forward. So we feel we did our part, and the owner can't be responsible because we have no idea what's in there. Perishable items, hazardous items, we can't be responsible for people's belongings, and we make that very clear at the onset. You're storing this at your own responsibility.
May I speak, Your Honor?
In a moment.
Okay.
Ms. Reynolds, did anybody from Secured Self-Storage go and observe this unit and the damage that Ms. Diaz and Mr. Hernandez are claiming?
I do not know that, Your Honor. I'm in Spokane, Washington at the corporate office. Mr. Paul Gindry, who is here with us today, is the on-site manager, and he may be better able to address that question. May I invite him to join us?
Please do.
Paul, please unmute.
Hello, Your Honor. To answer that
question. Did you go and observe the claim damage in this unit?
Yeah, to answer that question, I don't recall at the time if I did go to this specific unit and observe the damages. I believe I did, but again, this instance happened well over 3 years ago. And that was when we came up with the proper solution of either relocating the storage unit, or they had an opportunity to vacate the storage unit as well.
When you say we came up with the proper solution, was that a negotiated solution to the damages?
Your Honor, they came forward. They came forward with a problem, and we offered them some options that we thought might help the situation. It was in good faith that they could relocate down the hallway and provide a modest discount for 2 months of rent. We also did cancel the rent increase that the plaintiff would have received a couple days prior to this being brought to light. And as Ms. Reynolds had pointed out, the plaintiff did move down the hallway and continued their month-to-month tenancy with Secure Self-Storage from March through October of 2023, and we did not hear any further complaints. The plaintiff vacated the storage unit in October of 2023. We did not hear anything further until this case got brought before us a couple months ago.
Thank you. I would ask you in the next couple of minutes here, while I hear further from Ms. Diaz, to calculate the difference in the cost of the unit, taking into consideration the rate reduction and any other discounts that you provided for that 6 or 7 month time period that they remained a customer for you. You can think about that. I'll come back to you. Ms. Diaz?
Yes, Your Honor.
Go ahead.
Tell us about the pistachios.
One thing I just wanted to say is that I have the communication between us and Secured Storage through email. It's in my Exhibit C. It's actually between Paul and me. Nowhere did I agree that this was this would cover all the damage that was done. I do appreciate them offering that to us at the time, but it's extremely modest in comparison to the damage that was actually done. Another thing I wanted to point out was in my Exhibit I, there are corroborating tenant reviews. I did pull these from Google reviews, but there are multiple reviews that have a keyword rat or rat damage in them. And so I don't think that this was an isolated case at all. In addition to seeing those reviews, I can recall in the time that we spent there cleaning, I witnessed at least 2 other tenants discover their own rat damage.
Can you explain why we didn't leave right away?
Oh, and to cover why we didn't leave right away, I know in these reviews, Secure mentions that they're able to see when tenants visit their unit because there's a gate code to get in. I know that they can see that we hadn't visited for several months prior to discovering the rat damage in March of 2023. We had been traveling cross country to see our families. And whenever we got back in March, we were actually only planning to be in Olympia for several weeks before we were planning another big trip. Unfortunately, finding this postponed our trip by over a month.
How about her job? What does she do?
That's why we were gone in that time. Fortunately, we were able to come back in October. We had the funds and the ability to get everything we needed to move to a different unit, a different rental facility, sorry.
Oh, and the pistachios.
Oh, yeah. I mentioned it already too, but we didn't have any food in our unit. All of the units were accessible by rafters along the top of the ceiling, and we witnessed several times the rats moving along those rafters as well. Thank
All
you.
right. Well, what about the pistachio nuts? You're saying those weren't in your unit?
Oh, there is a photo with pistachio nuts in our unit. The shells were there because the rats had taken up a nest in our unit. My best guess at this is because we hadn't visited in some time. The rats just picked up on no action in our unit, and so they just fully nested in our unit. We did not have pistachios. We didn't have any perishable items in our unit.
All right. The rats would pick them up and then carry them back to their unit to eat them. Makes sense. They called it the pistachio unit. Or P unit. It's like G unit, but different. All right, have you done the math, secure self-storage? With what you gave her already, if we subtract that from their initial demand, I think that's what the payout's going to be.
Ms. Reynolds, awful lot of exhibits filed in this case on both sides. Can you point me to the contract for the original unit?
Yes, sir. Defendants exhibit packet pages 2 and 3, and I highlighted in yellow on page 3.
In rat ear in yellow.
Responsibility of occupant.
Your Honor, before we continue, I'd like to mention that none of the defendant's exhibits were filed by the August 7th deadline. As far as I know, they were given to the courts and myself yesterday through email.
Dun, dun, dun. What good is a deadline, Judge, if you don't enforce it? She's put in the work here. Give her the win. Yeah, Paul is on LinkedIn now, updating his profile. Self-starter, attention to detail. We obviously can't see the picture of the rat nest. The food being in the unit would be a deal killer for Miss Diaz. But if it was a rat's nest that it's showing a picture of, yes, rats do take food back to their nest. May I interest secure self-storage in a cat named Kiki? I think he can handle a rat because he takes out squirrels. So you then get a little bit of cat fur and that, but it's a trade-off, you know. We're going to go to the Hawaii trial in just a minute. They're just barely started hearing down there. We're gonna pop in. I want to see how this one ends. The rats have me intrigued. We'll go down to Mr. Koenig and what's developed there. They started out with some audio issues. I can fix those, but it looks like they've got them resolved for the most part. So we'll pop there in just a minute. Gimme Sue. My cat's name's Kiki too. Okay, Judge, we're ready for you to rule on this one. You just need the numbers.
All right, Ms. Reynolds or Mr. Olivares or Mr. Gingery, any response to Ms. Diaz's statement that there were no food items stored in her unit, that a nest had been created in her unit, and that's what the shells and the nuts were that were included in the photos that she filed? In response to that?
I'm not familiar with the day-to-day operations, Your Honor. I don't know anything about rats and their, feeding rituals. I'm going to turn it over to Paul Gingery, the site manager, please.
He's our rat expert, our resident rat expert.
Yeah, Your Honor, page photo 11 of the exhibit that Ms. Diaz did provide does clearly show a very significant amount of pistachio shells in the unit. Again, we're not experts and we cannot see things that we don't know about. This is something that very clearly shows that there was a substantial amount. I don't know if it would be possible, and again, I'm not an expert on the tendency of rodents going across pipes, to know that they could carry dozens, if not 100 or more shells into a unit.
They could grip it by the husk.
We do believe that this was something that existed in that storage unit at the time.
It's not a question of where they grip it. It's a simple question.
But once again, you can't be sure whether you personally observed that or not.
I didn't personally observe a rodent running across a pipe with pistachio shells, no.
And you didn't observe whether there was a nest there. You didn't observe those shells. The only time you saw them is in this photo. Is that right?
That is correct, Your Honor.
I think Ms. Diaz
May
needs
I
to
ask
start
Mr.
eating
Gingery
pistachio
for a
nuts.
unit count at the facility, please? How many units are at the facility?
Why in the middle of court are you asking him that?
There are 863 units at the Cooper Point location in Olympia.
Thank you.
Of which there are over 700 occupied at the time of this was brought to our attention. And we currently do have over 730 units currently rented and occupied at the facility.
How many of them are occupied by rats, though? Why is Jeannie just asking her people questions like that in the middle of the trial?
Ms. Reynolds, here's a question for you. in your exhibit in relation to storage unit 23050, which I believe is the first unit.
Yes, sir.
You say 02-03 B under that, P3, responsibility of occupant. Sub Roman numeral 4 says occupant agrees to indemnify and hold owner harmless against all claims and damages.
Correct.
What else is included there? Because you've left some portions of that out. Does that mean that the owner is responsible if, I'm sorry, the occupant is responsible if the owner is negligent in some way and damage occurs to the occupant's property?
I don't know about negligence, Your Honor. I'm not an attorney. I do know that we have 863 units. I do know this is the only claim filed. I do know that we have no inventory checklist on what each guest stores in their unit. We encourage that they get their own insurance to cover their belongings, and we do our best with pest control twice a month. Again, we cannot be responsible when we don't know what you're putting in there.
If you're twice a month, pest control isn't cutting it, though, and you're notified of that, and you don't change anything.
Your Honor, I do have the rest of that statement in the contract where I think you were asking the question, what else does it say? I will read it right here, and it is in part of that exhibit highlighted, but it does say occupant agrees to indemnify and hold the owner harmless against any and all claims, damages, costs, and expenses, including attorney fees arising from or in connection with the occupant's use of the storage unit.
But guess what? If you guys don't meet what you're responsible for, that negates that rule. We're going to cover Koenig in just a minute here.
And the argument, and this can be answered by any of the folks from Security, the argument is that the occupant's use of this unit violated the condition about not storing any perishable items or food items.
The response is that the owner is not responsible for damages to the content.
It's a good business model. We're not liable for anything. It's all your fault. Deidre, we're going to fix the sound. It's almost, right now, the Hawaii trial is almost impossible to even hear. I mean, it's like, it's terrible.
No, I mean, some part of June, but when I was on leave, I was off fighting. Yeah.
Approximately from when to when?
That's the Hawaii trial sound.
It was, I believe.
You got one mic working, one not. They keep cranking the sound up super high on one, then it's super loud, and then it's down on the other. I'll fix it. I got the tools and the skills. We got the Hawaii trial able to be listened to.
May I speak, Your Honor?
Who's asking?
Jeannie Reynolds.
Ms. Reynolds, go ahead.
Again, I'm in Spokane, Washington. I keep going back to a storage facility with 863 units that maintains a rental average of over 700 units. This is the claim of an isolated Miss Diaz. They chose Clara's unit to have their pistachio picnic in. I'm having trouble there. I'm having trouble.
Put Paul under oath and ask him if anyone else has
If the
complained.
unit next door had hazardous materials and the propane blew up, would the owner be responsible for all the units that got affected? We can't be. We encourage the occupants to carry insurance.
Well, if you knew they had propane and they weren't supposed to, then yes, you would be liable.
Yeah, I can see your point to an extent.
Thank you.
There is a difference between propane blowing up and rats in the rafters.
But the issue is the same, property damage to the occupant's unit. And that's why we're here. It's small claims court. It's
We'd be hard pressed to, I think Ms. Diaz would be hard pressed to claim negligence if the
propane situation.
Propane blew up. Also, Ms. Reynolds, I did see in the exhibits filed by Ms. Diaz a number of other folks that were complaining about the unit and that they had experienced a rodent infestation or a rodent issue. This is really a difficult situation. These contract provisions, such as you point out here, the responsibility of the occupant, I don't know, although I would guess I know the answer, that when this was being negotiated or when this unit was being discussed by Ms. Diaz and Mr. Gingery or whoever was in his place at the time, that this business of the responsibility of the occupant was specifically negotiated and that it was highlighted that you're not to store any food items. I can understand that one. But to say that the occupant agrees to indemnify and hold the owner harmless against all claims and damages regards to the occupant's use of the unit.
They didn't use it improperly.
And then to bring it up in this situation seems to me to be not likely that it was specifically negotiated for.
Well, Your Honor, Mr. Oliveras.
What's troubling to me is that on one hand, you can say, well, we don't know what people put in their storage units, but they're responsible for whatever it is. And we see these shells from pistachio nuts, and so they must have been put in there by Ms. Diaz. That's certainly a possibility, but it's also a possibility that the rats brought them there, especially if they were nesting there. That's not an unreasonable conclusion or assumption to make.
Your Honor, we cannot promise there are no vermin. We cannot promise. That's why we have the pest control twice a month. We encourage that you get your own insurance to cover your belongings. Again, if we have less than a handful of complaints on a Google search, if defendant would have known, I'm sure we can find the same amount of 5-star reviews on the Google search. It's a large facility.
Paul's like,
we
well,
maintain a high
really.
occupancy. And this is an unfortunate situation, but it's not the owner's fault.
Your Honor, if I may as well just add to that, this facility has been open since 2019. And as Ms. Diaz has pointed out, a Google review search will indicate the word rat has been mentioned on 4 reviews. Since Ms. Diaz started her storage tenure with this facility, we have had roughly 1,600 to 1,700 customers come and go. And
why did they go?
If it were me personally, if I had a situation like this, I would take to Google and I would let everybody know about it. And I do want to stress that there have been 4 in the last 7 years. That is what we're talking about here. So to use the word infestation, I don't think is appropriate.
Somebody do a Google check. When were the reviews?
The facts.
Your Honor, if I may, I just want to reiterate that this is not about whether or not Secure Self-Storage had rodent control in place.
What location was
It's
it?
just simply about the fact that whenever I mentioned it to the district manager, Paul, he notified me that they had been aware of the problem for 2 to 3 months. And he told me that they had been getting phone calls for 2 to 3 months. That is what made them aware.
Mr. Gingery, what's your response to that?
We did have more than one customer bring it to our attention. It wasn't a significant amount. So we were already aware that in the facility there was more than one customer, but again, not very many. And if it is an isolated situation, we did have pest control in place, and we did communicate with our pest control to make adjustments. And we have maintained that pest control in place for twice a month, and there are no issues, and the issue stopped.
Mr. Gingery, is this facility a one building, multiple stories, or is it a series of buildings, separated buildings?
It's a series of separated buildings, but the main building is multiple stories. It is 3 stories. And that is where the Miss Diaz's unit was on the 3rd floor of that main building.
They have a 2.4 rating on Yelp.
And it is a very large building as well. That main building is roughly, I don't have the exact measurements, but I believe it to be in the neighborhood of around 110 to 120,000 square feet for that main building. It's very large.
And Mr. Gingery, do you get reports from the pest control people each time they come to the building?
We do, Your Honor.
Felicia
and did they ever indicate that they determined that there was an increased activity in rats or rodents in the big building we're talking about here?
There were conversations had back and forth between us and the pest control company. They were able to isolate certain areas where they thought that there might be a larger issue, or where they thought that they might find them, and they eradicated the situation. But not at any point, there was nothing that I can recall that called it an infestation.
So did they report that they killed 20 rats, 10 rats? How did they report that they eradicated the problem?
Eradicated.
The signs were not there. There was no droppings found. There was no, and I don't know about numbers. Like, that wasn't how this works. They did place traps, and eventually there were none, and it just continued with very little activity.
Felicia says, inside unit was broken into and infested with rats. We were paying $250 a month to have our furniture ruined. That was on February 10th of 2024. So it looks like that was after this happened, because that was 4 years ago. It would be funny if somebody, I'm not saying to do this, but it would be funny if somebody left a review that says, best storage units ever.
All right. Ms.
Pistachio
Diaz, any
buffet.
last comment?
It's my favorite. Signed, Larry the Rat.
No, Your Honor.
Ms. Reynolds, any last comment from you?
No, Your Honor.
Well, it's a difficult case.
He's going to split the baby.
Property owner points out big facility, very few complaints. The fact that there are very few complaints does not change the situation for Ms. Diaz and Mr. Hernandez, that their complaint is real. Owner of the facility points to the contract, which contains lots of owner-friendly language that is not specifically negotiated between the parties when it comes to what the actual expense of the rent will be and so forth. But on the other side of that, the user of the property signed off on that agreement and arguably accepted responsibility for these items. Really don't like those kind of sort of adhesion contracts where the renter doesn't have much bargaining power in the negotiation of the contract.
It's like a predatory loan, but with reverse.
Owner talks about doing a rent reduction and a change in the unit and giving a discount to the occupant for continued use of the property. Apparently, there was no specific discussion about the damage to the personal items that were in the storage unit. Owner of the property or operator of the property did not specifically state, at least it's not in any of the documents, what the condition of the unit that they vacated was when it was vacated. Owner operator suggests that this rent reduction and change of unit was done in lieu of or in satisfaction of any kind of damage claim, although they haven't said that in exact words. That's the suggestion. Owner operator indicates that the pest control people did indicate that there was a pest control problem and that was isolated and then eventually eradicated, although we're not sure exactly what that means and how that works. It's probably not fair to hold the owner operator of the property to be a expert on rat or other rodent behavior. That's what the pest control people are for.
There are lots of complaints about Michaela, who works in the office there, on the Google reviews.
Having said all of that, however, Ms. Diaz and Mr. Hernandez, I don't find that you have met the burden of proof of a preponderance of the evidence here that the responsibility for this, for the pet damage, the rat damage to your personal property is a responsibility of the owner operator of this facility. Again, I don't like the contract. I don't like the burden it puts on you. I don't like that the owner operator wants to hide behind the language and say, you've said you accept essentially all the claims. You're holding us harmless from all claims about your property unless you get insurance. And that's an interesting question. It looks like he did get insurance, but they didn't want to cover rodent infestation. Now, how coincidental that is. So, Ms. Diaz and Mr. Hernandez, Ms. Diaz and Mr. Hernandez, I don't find that you've met the burden of proof in this case. I'm going to have to deny your claim, as much as it pains me to do so. And so secure itself storage, I suggest, and I don't know how many times you've been sued over the years, but I suggest that you not pat yourselves on the back afterwards and think that this is a big victory for you. I think it should be an indication that you need to be a bit more vigilant in what goes on and not just sit back and say, you've accepted responsibility. I don't know what's in your unit. I don't know what's going on. Sort of see no evil, hear no evil, speak no evil. I don't think that's a responsible thing for you to do. On the other hand, I don't think that I have the ability to find you responsible in this case. So my ruling is, after having heard all of this, that Ms. Diaz and Mr. Hernandez, I'm denying your claim for damages in this case.
Ms. Diaz can't believe it. Tell them they have the right to appeal. Yeah, they failed. They were presented with the contract and failed to read it and understand that it was a terrible contract for them. Probably standard for the industry, but terrible for them.
All right. I've signed a small claims judgment in the favor of secured self-storage. Following a trial today, I'm denying the claim by Diaz, and so nothing will be awarded in this case. You can get a copy of that judgment document from the district court clerk's office, civil division's office next week. That's all. Ms. Diaz, Mr. Hernandez, thank you for being here. Ms. Reynolds, Mr. Olivares, Ms. Gingery, thank you all for being here and participating today.
Thank you, Your Honor.
All right. Let's do this. Let's go to Hawaii, shall we? Who wants to go on a vacation, a trip to Hawaii? Why is this not working? 174. Let's see if this fixes it. Might fix it. All right. Let's go. Let's pack your bags, everybody. We are headed to Hawaii. I was going to make a joke about getting flowers, but you can't say that nowadays. People take it out of context, and plus, I don't know if the act of getting those flowers placed on you is the word I was going to use. If you know, you know. So, all right. Let's see. Hold, please. Hold, please. We're going to zip down to Hawaii, and let's back up just a tiny bit because we've got some major audio issues.
1 CPC-25-373
Give me a second. We'll get this audio working.
The motion for new trial filed by the defense on May 15th, along with the state's opposition, filed on July 1st, and defendant's reply filed on July 22nd. Before getting to the motion itself, counsel, is there anything we should take up preliminarily? Mr. Garner.
Yes, Your Honor. From the state, given the court has reviewed the filings, I think all parties are aware that HRE 606B is heavily implicated in this hearing. As we all know, this is an evidentiary hearing. I would like the court to either make a ruling or take argument about the scope of HRE 606B with regards to the proposed evidence in this case before any witnesses testify if they are here, so that essentially we don't open that door to jurors talking about their mindset as they were deliberating. The rule is very hard and fast in the state's mind, and once you start the testimony about that, you've basically blown the barn doors wide open. So that's what I'd like to address before we call witnesses.
Mr. Otake.
Mr. Otake.
Thank you, Your Honor. Our plan today was simply to call the prosecutor investigator just to confirm a couple of things, and none of which would dive into the jurors' mental processes or deliberative process.
They think there was a juror
just to confirm
issue.
a few factual things. After that, we're not intending to call any jurors. We will be relying upon the recordings and the affidavit we submitted, and I think at that point we can have the 606 discussion. So I don't see why we would need to do that before we call the investigator, just to quickly establish a couple of things. But
so defense at this point in time doesn't contemplate calling any jurors?
Well, and I will.
At least at this point in time.
Not at this point in time. And but after further, we're going to have a discussion this morning, I'm sure, about that. But that's not the intention at this point in time.
How about you, Mr. Garnet? Does the state intend to call any jurors at this point in time?
No, Your Honor. The only witness the state has is present is Erwin Kili'ipuleole, the investigator from our office. This is, as I mentioned, an evidentiary hearing. The exhibits that were attached to defendant's motion do not automatically enter into evidence. They are required. Foundations have to be laid. They have to be authenticated. So without any of that, frankly, Your Honor, I'm wondering what evidence there's going to be presented at all in this hearing.
So I'd like to give the opportunity to Mr. Otake to present whatever evidence he wants in support of the motion. I understand that the application of Rule 606B is going to be of significant contention today, but if we're not calling any jurors, I think I'm comfortable waiting to actually flush out the details of 606B, especially for not having any jurors here today.
Well, I do have an objection to the court admitting and considering the attachments as they have not been authenticated or any foundation laid.
I understand. Anything else we should take up preliminarily?
Just that the public prosecutor's role is to seek justice, not conviction. So if he wants to make a hyper-technical argument to block the court from considering clear statements made by the foreperson as you deal with this important motion, I guess that's his prerogative. But I think we can move forward as we planned, and if the court has further questions or if we need to take that issue up further, we can as we progress here this morning.
Okay. Counsel, I appreciate your thoughts. With that in mind, any other preliminary matters we should take up?
Not preliminary, Your Honor. Thank you.
Nothing else from the state.
Then, Mr. Otake, it's the defendant's motion. It appears that you have at least one witness you wish to present in support of the motion.
We do, and that would be the prosecutor's investigator, Mr. Kili'ipuleole. But I think a little background on that is important, Your Honor. As you know, Your Honor set pretty detailed scheduling order in terms of briefing and whatnot. And so we filed our motion on May 15th of 2026. We included in there an affidavit from the foreperson. And of course, that was with Your Honor's explicit permission that we could speak to the jurors further. Following that, the it appears, well, we now know that the prosecutor's investigator went out and viewed the foreperson who submitted the affidavit on June 5th, 2026. Then their opposition was filed on July 1st, 2026, which would have been, 26 days later. And at the time they filed their opposition, they referenced that the investigator tried to talk to the foreperson, but they said something about how 26 days later, the investigator's report was not concluded, and therefore they did not include any reference to what exactly transpired in their opposition, even though the interview was 25 days earlier. Then on the next day, July 2nd, 26 days later, the prosecutor's investigator did complete their report day after the opposition was due, and then that report was then later turned over to us, I believe, if I'm not mistaken, after our reply was due. So that's just the background as to why we have to call him today. Had the report been generated, less than 25 days after the interview and given to us prior to our reply, we could have included this in the reply, but due to the timing of it, that's why we have to proceed this way. But it's a relatively short questioning, Your Honor, just to establish a couple of things. So it won't take long.
I'm not going to preclude your ability to present evidence, Mr. Otaki.
No, I understand. I'm just letting you know the context of why we have to do it. Thank you. So with that being said, we call Mr. Erwin Keli'i Pule'ole to the stand.
Yeah, the social media post that predicted the outcome of this trial, including the lesser that he would be found guilty of, was quite insightful, and it nailed it. Okay, we're still having lots of audio issues. We're trying to even things out as it comes from the court. They're still messing with stuff. Yeah, this is the guy who went on a hike with the wife and tried to either push her over the ledge and then inject her and smash her with a rock. And then another hiker showed up. It was a nurse. Two hikers showed up, her nurses, and showed up and intervened and safety. It's just terrible.
You do solemnly swear affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes. Thank you. You can have a seat. Counsel, I'm sorry, I should have mentioned this earlier. When you're examining witnesses and when you're addressing the court, because we don't have a live court, we ask that you make sure that you are projecting into a microphone, meaning that microphone is in front of you. You can be at counsel's table or up at the podium, your choice.
Thank you, Your Honor.
The judge whispers, use the mic.
Good morning, sir. Could you please state your full name for the record?
And that microphone's
Erwin
off.
Keli'i Pule'ole.
Sir, are you an investigator with the Honolulu City and County Prosecutor's Office?
Yes, sir.
How long have you held that position?
4 years.
I want to ask you about what appears to be an assignment you were given related to this case. At some point, were you asked to try to locate and interview the foreperson from the jury in this case?
Yes, sir.
Do you recall when you were asked to do that?
I believe it was June 1st.
June 1st.
Yes.
Are you aware that our motion was filed on May 15th that included an affidavit from the foreperson? Are you aware of that?
I'm not aware of the date it was filed.
Okay. But you're aware that there was an affidavit attached to our motion from the foreperson, yes?
Yes, sir.
And June 1st, you received the assignment. Were you eventually able to interview the foreperson or attempt to interview and made contact with the foreperson on June 5th, 2026?
Yes, sir.
Now, is it typically your practice to submit and document a report shortly after you interview somebody?
To document, yes.
Your report in this case
It's
is
so
dated
bad,
July
guys.
2nd,
They're doing it on their
2026,
end.
correct?
They're plugging things in and turning the volume all the way up.
And it's essentially roughly 2 pages long, correct?
Yes, sir.
It describes the history of you're trying to contact the foreperson, correct?
Yes, sir.
And then also includes some of the things that the foreperson said to you, yes?
Yes, sir.
One of the things that the foreperson said to you when you interviewed her is that everything on the paper that she signed for the defense counsel affidavit and everything that she said to the media was true. She told you that, yes?
Yes, sir.
Your Honor, hearsay.
Sustained.
Objection was hearsay. Sustained.
Well, can we approach?
Sure, come on up.
He doesn't know how to get past that. Put the mic right there, talking to the mic. Apparently we've got the mic in the bathroom and the toilet is stuck on flush. There's Mr. Koenig, the good doctor. This is the murder case that almost was. Became an attempted murder trial. The volcano is erupting right now down there. In Kiliau or whatever. Kiliau. I don't know how to say anything in Hawaiian. We're watching a hearing, post-conviction hearing in the Koenig trial in Hawaii. This is a doctor who was convicted of attempting to kill his wife by pushing her off a cliff or injecting her with a fatal dose of something or some combination of the three, and also hit her on the head with a rock quite a few times. The attempt was interrupted by some nurses who stumbled upon the scene and heard the victim crying for help. He went on the run and was later caught later that day. It's, I believe, the only trial we've covered from Hawaii, the whole trial. Kilauea. Is that how you say it? I'm going to turn down the audio until we get something else. Interesting, they've got a, is that a Sennheiser boom mic set up on the table? Those have a very narrow pickup pattern. Imagine if you were looking through a PVC pipe. Somebody said like a foot-long PVC pipe. And the picture you saw, whatever was in that picture, down the tube, that's the only sound it would pick up from something you could see. If you couldn't see it in that tube, you couldn't hear it. That's how a shotgun mic works. It sort of reaches out in a cone that widens over time, and that's pretty cool, huh? And grabs the sound just from that area and sort of excludes stuff from in the periphery. So having a microphone like that works very well if someone is very stationary, and you know exactly where their mouth is. But if someone stands up, suddenly they're outside that cone and you don't hear anything. Mele Kalikalamaka. Everything I know about Hawaiian I've learned from Finding Nemo. Mount Wanahakalui or something. Hamana. Yes. I believe Koenig will get a new trial. Ooh. Also, the hang loose sign that you see after surfing is called shaka. Is he in a wheelchair or a regular chair? Regular chair. Okay, they might be coming back here.
Also, thank you for the benefit of your thoughts.
Yeah, that's terrible.
Will overrule the objection. Allow Mr. Otake to continue on his examination. And the court is finding that would be consider what is and is not permissible and
We have a bad cable.
so as such, latitude can be given. So Otake.
Thank you, Your Honor. And sorry, Mr.
I can't fix bad cable.
That was the last question I had. I just want to ask it again. When you did have a chance to make contact with the foreperson, one of the things that she confirmed to you or said to you is that the paper she signed, affidavit she signed, and what was contained in it, and everything that she said to the media, she confirmed with you that that was all true, correct?
Yes, sir.
Okay. Excuse me?
Yes, sir.
Okay, thank you. No further questions.
Okay, this audio is terrible. This is so bad.
Now, you were originally assigned to try and speak with Ms. Atkins on June 1st, 2026. Is that right?
Yes.
How did you initially make contact with her?
I attempted to call. I got her on the phone on June 1st. She said I explained to her the whole situation of me trying to set up an interview with her. She said she'll have to talk to her supervisor and call me back by the next day to confirm.
Clarifying questions. When you said you called her on the phone, what phone did you call her on?
I called the district court's bailiff office
So
phone.
was this a personal phone or a business phone or what?
Work phone, I believe.
So you didn't call like her home phone number or her cell phone?
No, sir.
And when you just said you were talking to her to set up an interview, was your assignment to actually interview her yourself, or was it to set up a time for her to sit down for an interview?
It was to set up a time we could interview.
So on that week of June 1st through June 5th, you weren't actually trying to get a statement from Ms. Atkins, is that fair?
Yeah, no, sir.
I can boost the audio so you can hear it, but then if it gets static,
when you called her
it
initially
blows
on
our
June 1st,
eardrums.
you were able to speak to somebody who identified themselves as McCullough Atkins on the phone, is that right?
Yes, sir.
And during that call, she suggested Friday, June 5th as a date to potentially have that sit-down interview, is that right?
Yes, sir.
So she also stated that she wanted to talk to her supervisor beforehand.
Yes, sir.
And then she told you that she would call you back when she confirmed that she was going to sit down. Is that right?
Yes, yeah.
Did she ever call you back?
No, no, sir.
Did you ever try to call her back?
I attempted to call twice.
And did you again try to continue to call the bailiff's office at the Honolulu District Court?
Yes.
The rats.
So again, you're not going after her cell phone or her whole phone or anything like that?
No, sir.
The rats have been chewing on the cables in Hawaii.
So when you weren't able to contact her by phone again, did you actually make contact with Ms. Atkins in person on June 5th?
Yes, sir.
Can you explain how that happened?
So I walked over to District Court. Our office is right across the street where I work. I went to go look for Miss Atkins or her supervisor, who was identified as Jerry through these phone calls.
Jerry!
I was able to locate her supervisor, Jerry, and he escorted me to speak with Miss Atkins.
And where did you end up meeting with Ms. Atkins?
I believe it was on the third floor in the hallway area by the elevators.
Was anybody else present as you met with Ms. Atkins at that time?
Yes, the supervisor, Jerry.
And again, the purpose of this meeting was not to actually interview her on that day. It was to set up a future interview. Is that right?
Yes, sir.
Did you explain that that was the purpose to Ms. Atkins?
Yes, sir.
And she responded to you that she didn't want to talk to anybody from the prosecutor's office.
Yes, she didn't feel comfortable.
And she was visibly upset when you talked to her, right?
Yes, sir.
Her demeanor was...
Emotional, crying.
Ms. Atkins also, during that time, told you some things about her statements to the media, right?
Yes.
She told you that she didn't want to talk to the media, isn't that right?
Yes, sir.
She also told you that she was ordered by the judge to speak to the media. Is that correct?
Yes, sir.
She told you that she was ordered by the judge to speak to the media.
Yes, sir.
How many times did she say that?
She said it once, then I asked her again, and she repeated the same answer.
She misunderstood.
She also told you that she didn't want to be the foreperson. Is that right?
Yes.
And she told you that people had been contacting her and her family on social media. Is that right?
Yes, sir.
And that people had been showing up at her job.
Yes, sir.
She also told you that she met with the defense in this case. Is that right?
Yes, sir.
And that they prepared an affidavit or a declaration for her, correct?
Yes, sir.
At that time, hang on.
Please, continue.
So at that time on June 5th, were you familiar with the declaration that she had signed?
I wasn't familiar with any details about that declaration.
So you hadn't actually read it yourself?
No, sir.
Now, on June 5th, did you also give Ms. Atkins a date to call you back if she changed her mind and did want to give an interview?
Yes, sir.
Did she ever call you back after that?
No, sir.
Thank you. No further questions. Oh, I'm sorry. I do have. Oh, I'm sorry. So initially, you completed. Sorry. After June 5th, did you prepare a report?
Yes, sir.
Okay. And that report was submitted on July 2nd. Is that right?
Yes, sir.
When did you draft that report?
June 5th, correction. Yeah.
Okay. Were you on leave at any point in June?
Yes, I was.
Were you on island?
No, I mean, some part of June, but when I was on leave, I was off island.
Okay.
Yeah.
Approximately from when to when in June were you on leave?
It was, I believe it was June 15th, I left the island. Yeah.
And came back at the end of the month?
I came back at the end of the month.
Thank you for clarifying. No further questions.
Yeah.
Mr. Otake, did you get it right?
Sir, did you record the interaction you had with the foreperson?
No, sir.
And when you drafted your report, sounds like, what, several days later? Is that right?
I drafted it that day.
On June 2nd?
On June 5th.
On June 5th is when you drafted it?
Yes.
And so you summarized what was said, correct?
Yes, sir.
You did not have a recording of what was said, right?
No, sir.
One of the things you said is that at the outset, the foreperson told you she didn't feel comfortable talking with you, yes?
Yes, sir.
And then you continued to talk with her, yes?
She was continuing to talk with me, yes. Yeah.
No further questions.
Any other questions?
Just to follow up on that last little bit there, Mr. Filipe, these statements that the foreperson made about being ordered to speak to the media or not wanting to speak to the media, did you question her about these things?
She brought it up first, and then I questioned her again about it.
Thank you. No further questions.
Hawaii Rule of Evidence 606B stops a juror
no, thank you.
from testifying
Thank you for being here.
about their mental process, emotions, or how anything influenced their vote during an inquiry into a verdict. And courts cannot accept a juror's affidavit or statements about these subjective inner workings.
Any other witnesses at this point in time?
Your Honor, I guess the first, issue or question is based off of what was testified to today, that the prosecutor, investigator confirmed with the foreperson that she confirmed to the prosecutor's office that everything in her affidavit was true and everything she said to the media was true. Based off of that, we would like to admit into evidence her affidavit and all of the exhibits attached to her motion. And the reason, as I discussed at the bench, I think is worth stating here on the record. This has been very uncomfortable for the foreperson, and we have tried our best to proceed in a way that is least uncomfortable for her. She just came here to try and serve. She didn't want to get involved in any of this. Unfortunately, things were said after that prompted us to have to look into this. That being said, we are trying our best to, protect her privacy, to not aggressively, go after her. We never tried to interview her while she was at work in front of her supervisor. We tried to be a little more discreet than that. And as you see, I've been referring to her as a foreperson. I didn't even say where she worked, anything like that. For that reason, as she indicated to the investigator, as you know, this case has generated, national attention, and I can tell you she's not the only one getting awful emails. Our firm has gotten countless awful emails because this was allowed to be broadcast nationally. Nevertheless, we're trying to do our job, but also be respectful of a juror. And that's why the issue isn't, did she say these things? We know she did. She told the prosecutor's investigator that she did. It's recorded on the media, so we know she said that. The issue is, does 606 allow you to consider it? And if so, what is the impact of that? So I'd ask the court to accept these things into evidence, and maybe a hyper-technical application of the rules, maybe it's an issue. I would first ask the prosecutors to stipulate that they can come into evidence. I mean, they know she said these things, so I don't know why they'd want to try and block it through a hyper-technical application of the rules that would further make a juror who's just trying to serve be incredibly uncomfortable. And then we can argue about what the import of it is. But so for those reasons, I'm asking the court to accept the affidavit and the exhibits into evidence, and whatever you decide to do with it thereafter is we're going to talk about that. But so I guess that's a long way of saying, when you ask me if I have further evidence, it depends. Further witnesses, it depends on how you rule on this request. Thank you.
Mr. Varner, with respect to the admission of what has been marked for identification and attached to the defendant's motion as exhibits A, B, and C.
I have a bit of a record to make with the rest of each of these. So I'll start with Exhibit A. Exhibit A is a TikTok video that is cut so that the question being asked of the foreperson is removed. There's text overlaid. We don't know, as far as I couldn't find the full version of this interview anywhere after looking for it. It's incomplete. We do believe that, and I'm not being hyper-technical here, Your Honor, the requirement to authenticate evidence, the requirement for foundation is foundational. It's not hyper-technical. This is something that you learn in your first year of law school. That if you want to enter evidence, you need to lay a proper foundation. The evidence needs to be authenticated. So I do have objections to all three of these videos coming in. Exhibit A is especially problematic, being that it's cut. Exhibit B and C do appear to be more full conversations between media representatives and two of the jurors. Exhibit D is as I think I said in my memorandum, a printout or a screenshot of a YouTube video of a comment from the YouTube video. There's no authentication as to who made this statement, no indication of its reliability.
What channel was it on?
It's frankly an anonymous internet comment, so it's not admissible for that reason as well. All of this evidence, and like I said, there is a burden that is on the defense in any motion for new trial. They have to present evidence and make a prima facie case that the new trial is warranted. So ignoring that all, admitting this evidence is very problematic to the state. Lastly, the 606B issue applies very heavily to all three discs of the interviews. They are very clearly the jurors talking about their internal deliberative processes. So this evidence will be barred under 606B as well.
I have a question for you on that point, Mr. Varner. 606B bars the use of the evidence for decision-making purposes. That would be the state's argument, I understand that. But what about the making of the record? If, for example, the court denies the motion and it's appealed, shouldn't the appellate court know what's there, but the court actually kept out? 606B, 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 606B,
Well, it's already in the record being attached to the memorandum.
That's the circular way to put it as well, right?
So yes, it already is in the record, and I'm sure the court has already had a chance to review all the exhibits that were attached to the memorandum, as well as any court would do with anything that's submitted to a memo. So maybe the point is more academic. That being said, it does still bar the admission of these for this hearing. I'll just add that 606 is not a permissive rule, Your Honor. The court may not enter these into evidence.
I understand. So if it's part of the record already, in the end, I mean, the elephant in the room that we're all going to have to discuss is the application of Rule 606. But the exhibits that are attached gives us the basis on which to ground the argument and give us a reason to talk about 606.
Yes, but I don't entirely agree. One of the cases that I cited in my memorandum was State v. Kim. And the procedural history of that case was there was a similar motion made where a juror had provided an affidavit after the trial, essentially alleging misconduct, some of her own, or alleging reasons for making a decision that were not based on the evidence. In State v. Kim, the trial court, ruling on that motion, denied the request for an evidentiary hearing at all. And that was what was affirmed by the appellate courts.
They're still messing with
so
the audio.
I don't think it's necessary to admit these in this case. Frankly, although we've already had evidence, I don't think it was necessary to have an evidentiary hearing in this case at all.
Understood. Thank you. Mr. Otake, the court takes under advisement your request to admit what has been marked for identification of defendants exhibits A, B, C, and D. I would like, though, to proceed and hear your thoughts on the application of Rule 606 and the rest of the arguments that are in your motion. For the purposes of argument today, you can assume those things have been reviewed by the court, and the court has reviewed them, and they're germane to what we have to decide today.
Thank you, Your Honor. And again, then, that makes sense so long as we reserve the right to do what I would hope we'd all want to avoid for the sake of the foreperson. We reserve the right to call her if there's truly going to be some foundational issue to admitting these things.
So no other witnesses at this point?
No other witnesses, just argument.
Mr. Garner, did the state wish to present any witnesses at this point in time?
No, Your Honor.
Yeah, Mr. Park, I'm happy to hear your arguments in support of your motion first.
Thank you, Your Honor. Well, I want to thank the court for your time. One thing, anyone who practices before you for any number of years, we know that for matters like this, of all judges, read everything, prepare, do your own research, and I'm sure you've done that in this case, and we appreciate that. As we know, the jury in this case did come back and return a verdict of attempted extreme mental and emotional disturbance manslaughter. In doing so, they implicitly rejected several things. They rejected that Dr. Coney had a calculated plan to take his wife up on that hike and kill her. They rejected that this was a premeditated attack. And thankfully, what we learned after the verdict is that they apparently rejected that he had an intent to kill his wife at all that day. We've learned that after the verdict. We also learned that the jury did not unanimously agree that he was guilty of attempted murder, something that needed to happen before they could even consider what they ended up on, the extreme mental and emotional disturbance manslaughter. So this motion today presents you with several opportunities, and an opportunity to prevent an injustice by overturning what we've learned is an illegal verdict that did not comport with the law that was given to the jury, an opportunity to right a wrong, and an opportunity to enforce the rule of law in your courtroom. An opportunity to say loud and clear that whether inadvertently or on purpose, whatever, jurors need to follow the law in your courtroom on multiple fronts. I just want to highlight a few things. Like I said, I know you've read it all. Let's start first with I think what is one of the most pivotal issues. Obviously, is what does 606 HRE 606 allow you to consider, and what it prohibits you from considering. And I'll start by pointing out what I hope
focus
is obvious
on the
to
objective
Your Honor and
misconduct.
everyone, that Rule 606 it doesn't impose a blanket prohibition against anything a juror says post-verdict. And it would have been very easy for the legislature to craft or promulgate a law or a rule that did so. It could have easily said and used language that was altogether restrictive. The court shall not consider any comments or statements made by a juror post-verdict in a challenge of the verdict. It would have been very easy to pass a rule that said that. Instead, what the rules ended up being, it's a limited prohibition on the use of certain things. Not all things, certain things. And it's really important to look at the plain language of Rule 606. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify, and this is the important part, concerning the effect of anything upon the jurors or any other juror's mind or emotions as influencing the juror to assent or to dissent from the verdict, as influencing them, the effect something had on them, the influence something had on them, or concerning the juror's mental processes in connection therewith. Mental processes. Let's break that down. The internal activities of the mind, how someone takes in information, how it affects them, how it makes them feel, why it makes them lean this way or that way. That process of digesting that information and the effect it had on him. Not the result of where they end up, but the process that they underwent mentally to get there. Not where they end up, but why they end up there. And of course, we shouldn't be able to dive into that. You know, if a juror says, I voted guilty. And okay, that's the result. Why did he do that? Well, I didn't think this witness was credible. I don't know, the DNA, you know, or I felt this about that. That's what 606 says we should not get into. And it makes sense because we don't want to second guess. We deliberately leave these decisions to the people, and we don't second guess their good judgment about how they feel about the evidence and how they feel about you know, we don't want to be critical and say, well, you should have found that witness credible because I think that witness was credible. You know, we don't do that. So that's what, understandably, Rule 606 is meant to prohibit. And we are not asking you to consider any of that at all. We're not asking you to consider the deliberative process, the mental thought process, the decision making, the effect things had on them that ended up with the result. We're not asking you to consider any of that, or what impact the evidence had on them. You know, we're not getting into, you know, the DNA evidence of how, you know, how the Miss Koenig's DNA was all over the rock and things like that in her hand. You know, we're not getting that. That is what we're prohibited from doing. Not the mental process. We're not asking you to consider any of that. We would agree that 606 would block that. But what the rule allows you to consider, and what we're asking you to look to consider here to prevent injustice and a wrong, is the result. Where every juror ended up, not how they got there. And you know, so for example, I'm going to get into this later, but you know, this idea that the statement that, you know, I did not believe he had an intent to kill her. I did not believe he was not guilty. I did not believe he was guilty of attempted murder. Okay, that's not the mental process. That's the result, the objective result. Why did you not think that? You know, if she were to say, well, again, you know, I thought the DNA blew her story out of the water. I thought it was clear there was no premeditated plan. I didn't think the eyewitnesses were overly credible. I thought the cops were exaggerating. That's the mental process that we're not asking you to consider. How they got where they got is different. And the policy behind 606 and striking this balance, it makes a lot of sense. It makes a lot of sense. And from the commentary, it says, Rule 606 commentary, it is meant to strike a proper balance by excluding testimony relating to the internal deliberative process and allowing testimony about objective misconduct and irregularities. So irregularities. If there is objective evidence of irregularities, you must consider it, obviously. Because if not, then we're letting this rule of evidence trump everything we know about the Constitution and due process and the right to a fair trial. And that's what they want you to do here. Use a hyper-technical not even that, a wrong interpretation of a rule to override constitutional rights to a fair trial, to a unanimous verdict, to due process. And that's why when they drafted this rule, they didn't do that. They struck that balance so that courts, when fortunately, not by anything we did, but on the juror's own voluntary statements to the media after, when it is uncovered that there is an irregularity, as we have here, it allows the court to do something about it. And that's why the rule is written the way it is. HRE, this is from State versus Holbron, 80 Hawaii 27. HRE 606 does not foreclose judicial inquiry into irregularities affecting verdict integrity. And that's what we're saying here. And to interpret the rule the way they're interpreting it, or asking you to interpret it, would render it unconstitutional. We all know that rules can't trump the Constitution. But you don't need to do that. You interpret it the way the plain language says, and it can all work together. Then okay, we apply the rule the way it's meant to be applied, and we apply the Constitution the way the Constitution is meant to be applied. And that's the thing. I guess if when the rule says you cannot consider their mental processes and everything I just mentioned, what do they think that means if it blocks what we're asking you to consider? If it blocks what we're asking you to consider, then that doesn't mean anything. That means you can't consider anything. And so clearly the rule allows you to consider some things. Let's look at then, with that application, what you can consider and should consider. The statements to the media and the declaration of the foreperson. The foreperson's statements to the media, it's all in our motion. I know you read it. The intent to kill is improbable to us. The jury did not believe Dr. Koenig intended to kill Ariel Koenig from her affidavit. From her affidavit, I believe Dr. Koenig was not guilty of attempted murder. From her affidavit. Sworn statement that that's why we did this, because if there's any doubt she said that, by all means, go interview her, which they did. And I don't know how they went about it that made her uncomfortable to talk to them and didn't record it. But now, in a report that's generated the day after a reply is due, or at least produced well after, but the point is she verified that what was in that affidavit was true. So what does that mean? She has told the prosecutors that what she said, I believe Dr. Koenig was not guilty of attempted murder, that's a true statement. Juror number 3, I don't know if he was trying to kill his wife, but he had the capacity to kill his wife. Now here's the thing. Here's the part I frankly don't understand. I'm not so sure what the prosecutor is saying today about this, because the opposition was filed when it was filed, and presumably they meant what they said in their opposition. And let's look at what they said in their opposition about what you can consider. And it's on page 17 of their opposition that was filed by the state. Obviously, we have duties to the court when we file things, that we mean what we say. What evidence, this is their words, what evidence is left after HRE 606B is applied correctly is Exhibit D and statements number 1, 3, and 4 of the foreperson's affidavit. Statements 1, 3, and 4 of the affidavit. Statement 1, I was the foreperson. Statement 3, the jury did not unanimously believe that Dr. Koenig had an intent to kill his wife. They are conceding in their opposition filed in this court that you can consider that properly under 606. Statement number 4 from the affidavit. I did not believe that Dr. Koenig had an intent to kill his wife during the incident on the Polipuka Trail, and I believe he was not guilty of attempted murder. They concede you can properly consider that under 606. And at first I thought, is that a typo? And then I read what's before and after, and it's clearly not a typo. They believe that the application of 606 precludes, as I've talked about, mental deliberative processes, but doesn't preclude, an objective irregularity, result-oriented kind of comment. So they themselves say you can consider that. So let's summarize then with what they concede, what can and be properly considered, even by their own admission. Again, the intent to kill is improbable. Did not know if he had an intent to kill. Jury was not unanimous as the intent to kill. And a foreperson believed she believed he was not guilty of attempted murder. So, if you can consider, because you can't consider all of that, the verdict just cannot stand. It just can't. It's undisputed how your instructions worked and how the law worked. Nobody, I think, is disputing that. There must have been a unanimous agreement to guilty on attempted murder before they could even consider extreme mental emotional distress manslaughter. We all know that. We all know that. We have a juror saying, I didn't believe he was guilty of attempted murder. I didn't believe he had an intent to kill her. So, and if it was not unanimous, the instructions then direct them to go to the assault charges, which did not happen. And, I think we can all agree that even for us lawyers, the instructions are complicated. So I'm not faulting the jurors. I mean, they're human, they're trying their best, but mistakes happen. Misunderstandings happen. And that's not a failure of the system. What's a failure of the system is when we learn about that if we don't take steps to correct it.
It's the trial of the doctor who tried to push his
that's
wife off
the way the law works.
trail
And
in Hawaii.
if there is an irregularity, there is an irregularity and a
Smashed
fatal
her in the
flaw
head
in the
with a
verdict
rock.
because it was not a unanimous verdict, and they did not follow the law the way it was given to them.
The Hole in the Bush song, remember that?
We talk about how at best, if you look at juror number 3 and what he says, at best that's a non-existent offense of attempted reckless manslaughter from the Stanley case, right? I don't believe he had an intent to kill, but maybe what he did had the capacity to. That's reckless manslaughter, and there is no such thing. And I guess I'd ask you to consider this. I mean, I know this isn't exactly what happened, but it's pretty close. Let's say a jury, and it's an important case. Obviously, he was facing life in prison, right? And let's say someone's facing life in prison, and a verdict comes back, and the juries find the defendant guilty of, let's say, murder. Let's say murder first, where he's going to be life without parole, the harshest sentence in our state. And then the foreperson walks out of this courtroom, and then there's cameras there, and the foreperson says, at her own volition, at no prompting, well, you know what? Yeah, at the end of it, 6 of us thought he was guilty, 6 of us thought he was not guilty, that they didn't prove it, but we just returned a verdict of guilty. I have a hard time believing that our appellate courts would let that stand. I mean, I would have a hard time believing this court would let that stand. I mean, that would be absurd. And that's essentially what they're asking you to do. Maybe not to that extreme, but pretty close. Pretty close when we know a juror has said they were not unanimous as to a required element, and she herself has said she didn't believe he was guilty of attempted murder. Meaning, at best, it was 11-1, which that's not what she was saying, but we can't just ignore this. We can't ignore this, and we have an opportunity to fix it. Just to address some of the prosecutor's arguments, we're not invading the power of the jury to act independently. I'm not sure what they mean by that, but we're not. That's the part, the independence of being able to think through things, consider evidence this way, give credibility, weight that way. Yeah, that's their independent right. What they don't have a right to do is not follow the law. That's different than invading their power to act independently. We're not invading jury secrecy. They came out and she said what she said. When you allowed us to talk to her, she said what she said.
We never did, nor will we ask her, we didn't ask her, why did you, how did you end up over there? We're not invading their secrecy. We're not invading their freedom to deliberate. We're not harassing any juror. All of these statements were made freely at their own will. So, that was the gist of a lot of their opposition, is these policy reasons behind this. We're not violating that. And then again, it's a balance. Yeah, we don't want to inconvenience any juror, make any juror feel uncomfortable, but we also want to get it right and make sure that there was not an illegal verdict under the Constitution. For these reasons alone, a new trial must be granted. The text messaging, and again, we objected to this being broadcast nationally, but it was allowed. And, then a commenter on one of these live streams commented during deliberations, before the verdict was returned, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. And there's a couple of significant things about that. It says, I've been texting with, which infers a conversation, multiple texts. I've been texting with one of the jurors. It infers an ongoing conversation. The use of the term count 3, they're going for count 3 attempted manslaughter. No one in this courtroom ever referred to anything as a count. Nobody said the lessers is count 2, count 3. Nobody said that. We pointed out how in the statements to the media, one of the jurors did use the term, we went through all of the counts. So one of the jurors in the deliberation room, apparently the term counts was being used, even though we didn't use it in this courtroom. And now this person is using the same term. They're settling in on count 3. What else do we know about that? On the verdict form, although it was not indicated as counts, the third option, which would be, if you wanted to consider them counts, count 3, was extreme mental emotional disturbance manslaughter. So he said, and presumably, I don't think the verdict form was even publicly accessible at that time. So some guy, wherever he was, and somewhere on the mainland, would have never known that count 3 was extreme mental emotional disturbance, or at least the third option on the verdict form. But he used that term. He didn't just say they're going for attempted manslaughter. He said they're going for count 3 attempted manslaughter, using the same reference to count as a juror did to the media, and picking the number on the verdict form that was EMED. And then lastly, that he correctly predicted the verdict. And there's case law we cited about the import of when somebody correctly predicts something, how it provides an indicia of reliability. So there is indicia of reliability to lead to concern because of that. And I don't believe it is something where we can say, maybe it was just this or maybe it was just that. Remmer versus United States, the United States Supreme Court case. Private communications with jurors during trial concerning matters before the jury are presumptively prejudicial. Presumptively prejudicial. And the burden rests heavily upon the government to establish harmlessness. That's our United States Supreme Court. Our Supreme Court, 76 Hawaii 172 State versus Voritani. Once a defendant makes a prima facie showing that an improper influence may have affected the jury, prejudice is presumed. Prejudice is presumed. And the state must establish beyond a reasonable doubt that this misconduct did not affect the defendant's substantial rights. From what we've submitted and the arguments we've made and the inference and the indicia of reliability related to count 3, accurately predicting it, the timing of it all,
the burden shifts.
We made a prima facie showing. The burden shifts to the state to establish beyond a reasonable doubt that it did not happen or did not affect his substantial rights. What did the state do to meet this burden? Nothing. Nothing. It doesn't appear they went and, you just saw they have investigators that work for them full time. Probably many of them. And that's why we put the burden on the government, because they're the ones with the resources. They're law enforcement officers with the right to subpoena things, to get search warrants, to interview witnesses. If they believe there was tampering with a juror, that could be a crime. They could, call people to the grand jury. There's any number of things they can do to meet this heavy burden of trying to show beyond a reasonable doubt that my client's rights were not affected. They did none of that. Call your investigator. Tell us what you did to figure this out, because I would assume you'd want to figure this out. I'd assume you'd want to know, in your role of seeking justice, not just convictions, did this happen? This is concerning. We should look into this. It's not only our burden, but it's our ethical duty to, if there was misconduct here, we want to know. What did they do? Nothing. I don't think they wanted to know. I think they were afraid of what they would have learned. So a prima facie showing has been made, and they have done nothing to meet their burden to establish beyond a reasonable doubt that this misconduct did not affect my client's rights. Prejudice is presumed. We don't need to show harm. Prejudice is presumed. State versus Furutani. Remner versus United States. Presumptively prejudicial. I come back to what I said earlier, Your Honor. This motion raises important questions about what you are okay with in your courtroom. And I mean that respectfully.
You said it in a way.
Do the jurors have to follow the instructions? The jury instructions, I'm not going to go through all of them, but many of them directly call into question what happened here. You are the judge. This is number 2, page 2, from the instructions. You are the judges of the facts of this case. You will decide the facts, what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. They're told they have to follow the way the law works. Page 16 of the instructions. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required state of mind, as these instructions specify with respect to each element of the offense. That's the law. They took an oath to uphold that. We now know that that was not a unanimous finding as
Sean,
to the requisite
thank you.
state of mind.
OG Sean. Appreciate it.
We talked about the elements on page 19 and what was required before they could unanimously find guilt on the attempted murder. We talked about how one juror said she didn't believe he was guilty of attempted murder. And then lastly, as to the text messaging issue, one of the last instructions that is given to them on page 43, during your recess from deliberations when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and has been received by the court. It's one of the last instructions you gave them, which raises the question, do jurors need to follow the law in your courtroom? Of course they do. Of course you're not okay with that. It would be an incredible coincidence if somebody, prior to the verdict, used the term count when nobody in this trial used it, and then the jurors used it, that they would know it was the third option on the verdict form, and that they would know and accurately predict the verdict. It would be an incredible coincidence. And we can't, there's too much at stake to just assume that it was some lucky guess. We have established a prima facie showing. There's presumptive prejudice. They could have done any number of things to try and meet the burden to show that it didn't happen. In closing, Your Honor, I'll say this. I'll be the first to admit, this is not ideal. I get it. I don't envy you being in this position. It's not ideal. It's not any of our faults. It's not your fault, surely. You ran a great trial. When I say it's not ideal, I mean this was a long time-consuming trial, resource-consuming trial, energy-consuming trial. And at the end of it all, for this to happen, nobody wants that. It's not ideal. But these things happen. It's a human system. Jurors are human. I'm not faulting them. It's in terms of the application of the law and the way it flows, if you find this, you go here, if you find that, it's confusing. Jurors are human. And again, I'll just say it again. The error that occurred here on the part of the jurors, inadvertently or advertently, it's not a failure of the system or a failure of how you ran this trial. This trial was run fine, that was not the issue. But allowing a verdict to stand. Yeah, well, I'm just, but I'm just saying, like logistically, I'm obviously we disagree on certain legal issues. I'm just saying logistically,
thanks, Troy.
It was run well, and I'm just saying sometimes these things happen despite our best efforts. But allowing the verdict to stand with clear evidence that it was reached in error, and not taking this opportunity to correct it, that would be a failure, and that would be wrong.
Thank you, Ed.
We ask that you do the right thing and grant a new trial.
We ask that you do the right thing.
If 606 and the language that is used there, this is exactly the situation. This is why the balance was struck when they drafted that rule, was to be able to take action when there are irregularities like this. And we cannot be dismissive of what was said and what we know about the texting. We can't. We have to err on the side of constitutional rights here, and it's all it is. It's just a new trial. We're not. It's all it is. So we appreciate your time, and we're asking that.
It's risky. Josh, thank you very much. 29 months, OG.
For the purpose of this discussion, the statements that you've been referencing, let's talk about that. It's an interesting way that was posed to these jurors, okay? And they come back thinking or stating that the defendant didn't intend to kill his wife. I mean, that's the crux of it, right? Did you think the defendant tried to kill his wife? No. And that's where we are today, essentially.
Thank you, SCJK.
If they were to be asked that
John,
question,
thank you.
And they would answer yes, the verdict is attempted murder, attempted murder in the second degree.
Assuming all the other elements were met, well, yes, as to the state of mind element.
Right. So they're asked the question: do you think the defendant tried to kill his wife? The answer is yes. The verdict is attempted murder in the second degree.
No, then they would consider EMED if they're unanimous.
But that's one way to think about it, right? If they say no, like you're arguing they did, we have some different decision or some different verdict where it can't be attempted murder.
Well, then they would have gone and considered us. They were supposed to go and then consider assault, not EMED, not extreme mental emotional disturbance.
Okay. Appreciate your clarification on that. So next question. The first part of the defendant's motion is predicated on, and your argument is clear here today, that they just misunderstood the instructions or they just didn't follow the instructions.
One or the other. It maybe, and I think it's helpful to say it in the reverse. Given what we know factually, there's no way they could reach that verdict if they followed the instructions.
Okay.
Yeah.
Flighty Heidi admitting to the felony. Sorry, Red.
We've had the jury system in this country for what, 250 years now. I can't imagine other jurors have not made the same mistake. Presuming that. How many cases do we know where we set aside the verdict when the jury says we didn't follow the instructions?
Well, thankfully, in 20 years, this is the first time that has been learned. And I would hope that every time we learn that, we will do something about it. And I'll say what I said that the consequences of getting something right is not a reason to get it wrong. So, if there's a concern that somehow this is going to open up floodgates, number one, I don't think that's a valid concern, because over 100 jury trials I've done, it's the first time I've ever seen anything like this happen. So it's not going to open up the floodgates, number one. So my answer is, anytime we uncovered that a verdict was not unanimous, anytime we uncover that there's irregularities, the court needs to act.
I'm not worried about the floodgates, at least at this point in time, right? But assuming that there's been mistakes on following the instructions before, right, there's no decision that says we set aside the verdict, right?
Well, there's a couple of things I'd say about that. The first is I think, Your Honor, you're assuming it was a mistake or whatever it is, whatever it was,
Well,
right?
that's the argument.
Well,
The first
it was either they ignored it or they didn't follow it, right? Or it was a mistake. Okay. I think, well, and we learned about it, so we have to do something about it. And what did we learn? We learned, and you know, the part that respectfully is left out of your questioning is the statement from the affidavit of the foreperson that said, I believe that Dr. Coney was not guilty of attempted murder. Right? So,
objection, that is not what it says.
in the affidavit?
It's not.
Okay, I'll read it.
I'll clarify what I mean by that.
Well, let me read it. Let me read
The
it.
past tense, Your Honor.
Let me read it. If I'm going to be accused of misstating something. Declaration of the foreperson, I'm trying to be respectful to her. Number 4, the statement they said is allowed into evidence. I did not believe that Dr. Coney had an intent to kill his wife during the incident on the Polypuka Trail, and I believe he was not guilty of attempted murder.
Red, thank you very much.
I think what I just said, she said, was, I believe Dr. Coney was not guilty of attempted murder. So I was just pointing out that that is a statement that was I know you didn't mean to, but the point is we know that, we have that. And I understand, I think I understand your question is does the law tell us what to do with that? I mean, the law tells us that when there's irregularities in a verdict and we learn of the irregularities to a point where it's, you know, in this case affecting his right to a unanimous verdict, which is just fundamental, we have to do something about it. It's fundamental. If there would be,
it's like foundation for evidence.
It's one of the most, I think, you know, serious violations of a trial defendant's right that, in terms of these types of challenges. So,
it would probably be
so I would
reversed on appeal
suggest
if they don't do this.
Implicit in the case law, when it talks about being able to use certain things, irregularities, to challenge a verdict, implicit in that is, of course, if we learn that for whatever reason there was, you know, either deliberate or not, that the laws were not followed, with something as so serious as a unanimous verdict and an element, that it would have to lead to the verdict being set aside.
Busy the Gamer Mom, thank you so much.
I understand the argument.
Yeah.
Which was slightly different. Like, assuming that the defendant's argument is right, that they didn't follow the instructions or they ignored it or whatever the case may be, they didn't understand it. This can't be the first jury that has done that. And I can't be the first judge that is tasked with making this unpleasant decision. I'm just wondering what other judges did.
Show me the case law is what he's asking.
We don't know, right?
Well, I mean, I'll say several things about that. I mean, if this ever happened before, where a juror came out on the news and said these things, I mean, if there was a motion and it was granted, there wouldn't be an appellate opinion, right? So I don't know. I mean, maybe it happened, maybe it didn't, but and respectfully, I'm not following why that matters. I mean, even if this is the first time it's being decided, we know what we know, and we should get it right. And I'm not saying that necessarily this is what you're getting at, Your Honor. But if in any way the thought is this is kind of a first impression and it's for the Supreme Court to decide, I disagree. This is.
Well, I'm not fluffing the job. No.
Okay, I know you're not. I just wasn't sure, like when you're saying it, I'm not suggesting that. I'm just saying, you know, I can't tell you if this happened before. I can tell you I've never seen it happen before. So to answer your question, I don't know. I can't tell you if it has or hasn't, but I can say if it did happen and a judge did the right thing and there wasn't an appeal, we wouldn't know. I don't see that as a reason to, if we know what we know. If we're not going to set aside a verdict after learning it was not unanimous, then I don't know when we would. And so, anyway.
No, I appreciate you giving thought and considerations to this question.
No, thank you for the question.
Thank you, Mr. Tucker. Mr. Lerner, state's opposition.
Your Honor, respectfully, I'll take a stab at answering the question you just asked Mr. Otake. There is a large body of case law where similar situations have happened. I have outlined all of these cases in my memorandum. I started with case law in Hawaii. I moved into the Ninth Circuit, and I went to other jurisdictions.
Nothing in Hawaii is specifically on point.
I disagree. So, in Hawaii, and if you want to specifically talk about misunderstanding, that would be State v.
Laeta. I'm sorry, State v. what?
State v. Laeta. It's on page 11 of my memorandum. The proffered affidavit, and just for a bit of background, State v. Laeta was a case involving a issue that came up at a trial where one juror raised an issue where he didn't understand the proceedings in the trial. The juror was voir dired by the trial court judge.
I asked the question of instructions. That's one of the disputed points of the defendant's arguments is they just didn't follow the instructions. They didn't understand it. Or they ignored it. Some combination of those things.
I have Ninth Circuit then for you, Judge Vasquez v. Walker. Started on page 12 of my memorandum. The court noted the trial judge had read the instructions. The jury had an opportunity to ask questions to clarify, which the jury did in this case as well. The jury knew how to use the communication forms and in fact did send communications, but did not ask any clarifying questions of the court. The Alaska Supreme Court in Myers v. State. Clearly written instructions may be clearly written instructions may be misinterpreted by a juror is simply one of the hazards. The misinterpretation is an inquiry into the juror's mental process, and getting into that would violate 606B. So I do think that there has been a lot of case law about these issues, about misunderstanding, mistake, in Hawaii and other states that show that this is not a reason to grant a new trial. Taking a step back, the big issue here is, of course, what started all of this is the statements to the media by two of the jurors. In those statements, the jurors are asked to explain how they reached their verdict in this case. There could not be a more heavy indication that what they're talking about is their mental process in coming to their verdict. Now, one of the exhibits was cut off for the question. The second exhibit, involving the foreperson, she was directly asked, how did you get to manslaughter, or why manslaughter? And that's when she started to explain. So these statements are directly the jurors sharing their mental processes. This is not an objective misconduct. This is not anything other than clearly violating Rule 606B. And I don't know how to put it more clearly than what's actually in front of the court. I do want to point out that defense, in their reply memorandum, also stated that their motion is predicated on this inadmissible evidence. Dr. Koenig relies only on the portion of their statements that identified the jury's determination underlying the verdict. It's on page 7. The statements underlying the verdict, the reasons for how they got to the verdict. That's what we're talking about here.
It's mental process.
All of this comes from those statements. Taking a minute to talk about the application of 606B. I did do a application of 606B in my memorandum, and I did indicate which proffered evidence that would potentially, or that the court could consider under 606B. I want to be clear, though, when I say that statements 3 and 4 can be considered by the court. Statement number 4 is all in the past tense, despite being misstated as a present sense statement by the juror, by the foreperson. We don't know when the foreperson believed or didn't believe this, based on the affidavit that the defense prepared for her. It's completely unclear. So I don't have enough information to tell you whether this violates 606B or not, because I don't know if this is in deliberations, if it's sometime before deliberations, if it's a statement for a state of mind she had after deliberations. The information is just not contained in this statement. If the statement is applied as her mental state during deliberations, then it would be inadmissible. But I can't. Then it would be inadmissible. But I can't say that because I can't assign anything further than what is actually written on the paper. And the foreperson is not here to testify as well. Not here to face cross-examination about the circumstances of this. Not here to face cross-examination about who prepared this for her, whether she understood it, whether she had legal representation, what statements were made to her in the process of signing this. All these questions have been unanswered by the defense failing to present this witness, and more. So when I say that the court can consider this, yes, you can. It just has no relevance to the court's determination because there's no time assigned to it. With regards to statement number 3, the jury did not unanimously believe that Dr. Koenig had an intent to kill his wife. Again, there's no time.
Past tense.
There's no time element to what this statement is. And there's also the issue of polling. The purpose of polling is to let jurors who have lingering doubts, that have a doubt later on or that have second thoughts. The purpose of the polling is to let them voice those. It's kind of a speak now or forever hold your peace kind of moment. And that happened in this case. And every juror said they agreed with the verdict as it was read. So, yes, you can consider statement number 3. It just doesn't have any effect because the jurors were polled under oath when they swore that oath to return a verdict according to the law and the evidence. They were polled. They all said they agreed. Overall, what we're asking here, Your Honor, is not to deny this motion on a technicality. And that's the reason that I spent so much of my opposition going through the history of jury trials, the history of jury deliberation, jury secrecy, the history of all this stuff, because it's fundamental to the jury trial system that the jurors don't have their internal deliberative processes examined, brought up, testified to, cross-examined on. All of those things stymie the entire purpose of jury trials. Well, the court sounds somewhat reluctant to consider the effects. There is a chilling effect on future trials if we start opening those doors. There's a massive chilling effect. Any juror in a case against somebody who's potentially very popular publicly, a sports figure, somebody like that, any juror would be pressured knowing that their verdict could be attacked, that their thought process in reaching their verdict is not secret. It's essentially what we're asking, what you're being asked to do is to break the promise the judiciary made to these jurors. We bring these people in. We ask them to serve, to sit for a month, and they're told that their deliberations are secret. And it is an incredibly, essentially, if you do not believe in secrecy of deliberations, you do not believe in jury trials. As simple as that. So this is not a technicality. This is something where there has been a large body of case law of similar issues in Hawaii, of the exact same issue in other states and the Ninth Circuit. And all of that case law shows that this is inadmissible. Even defense's own admissions that what they're seeking to do is to get into the mental process. I know it's stated several times throughout defendants' original motion and their opposition that they don't want to, that's not what they're trying to do. But in fact, that is what they are looking at. They are looking at the internal deliberative processes of how these jurors came to their verdict. It's not objective. The objective misconduct examples are all throughout my memorandum. You know, when a juror brings in outside evidence to the jury room, objective misconduct. When a juror makes a decision and introduces their own life experiences similar to a victim, objective misconduct. But what all those cases are also very clear on is the court cannot consider the effect of any statement made. Right? So objective misconduct is admissible. That's not what we're talking about here. We're talking about how the jurors got to their decision. We're talking about trying to get into their heads. And that is hugely problematic. And frankly, it is inadmissible for not just policy reasons, but because it's fundamental to the jury trial system in this country. Moving on, getting closer to the end here, Judge.
Keep it brief.
To the YouTube comment. It's an anonymous YouTube comment. The defense is citing the U.S. Supreme Court case, I believe Renner. In Renner, the contact between the outside person and the juror was known. The juror reported it to the court. There was an FBI investigation in that case. There's an FBI report prepared. It's clearly distinguishable from this case where there is no confirmation of juror contact. The specter has been raised, yes, but it is defense's burden to actually make that prima facie case, and they haven't. So we're citing a case with a completely different set of facts and trying to apply it to the same way, and that's not what we have. What we have is an anonymous internet comment. Anytime there's a high publicity case, anytime there's a case that is on the internet, which there are certainly going to be more to come in the future of any jurisdiction.
I certainly hope so.
Anytime somebody makes a comment claiming to have inside knowledge or claiming to know something else, anytime that happens, what defense is saying is that should be an automatic granting of a new trial. And that's not true. Lastly, you should consider the actual context of this statement on its face. There's no statement indicating that there was communication, anything other than potentially somebody leaked the verdict. There's no indication of any talk about discussing with the juror how they thought about things, convincing the juror to vote one way or the other. There's none of that. So for that reason as well, there's no prima facie case. So overall, what defense is asking you to do is to get into the juror's mindset of how they ended up at the verdict they ended up. That's what this is all based on. And although they can say it's not what they're looking for, unfortunately, factually, it is. That's how these statements came about. That's how these things were raised. And that's where we're at. And that's why 606B applies. These statements are inadmissible, and the court should deny this motion.
Thank you for your whole presentation, Mr. Varner. If anyone else have questions for you as well. If the court adopts the state's reading of the strict bar on admissibility of juror comments provided in 606B, Hawaii case law does, though, allow the piercing of that shield to determine if there was outside influence on the jury, meaning jurors can be asked whether or not outside influence affected the decision making. 606B doesn't prevent that. It's under case law, right? You're nodding your head. I'll take that as a yes. Yes. Sorry.
I'm waiting for the question.
So I understand the argument about perhaps the defense not making the prima facie case. But there is certain case law that places the duty on the court to further examine and investigate if there is, and I want to use the word in either parentheses or air quotes, credible interference or credible communication with the jury during deliberation. How strict is that bar? What level is that prima facie evidence? Do we not have it here?
To clarify before I answer, Your Honor, are you speaking about, and actually before I get there, I don't believe,
right? Exhibit D says I had contact with the juror during the deliberations. Yes. Do I need to investigate?
I think that's up to the court. If you want to investigate and bring in the jurors, I know that has been done in several of the cases the state cited. The court has brought in the jurors to testify.
Say like the Maya trial.
The best I can say is that's unfortunately in the discretion of the court, but it is in your power.
Unfortunately. Unfortunate for you.
I didn't see anything in my research that said it's a requirement. And to clarify, I don't think there's a strict bar against against statements by jurors. I think that I've said it very well that strict bar is only as to their mental processes, not as to objective misconduct. The case law is very clear. Objective misconduct is admissible.
I understand that Hawaii case law says it's discretionary. But really, when we look at State versus Chin, isn't it urging the court in that direction?
I did not brief State v. Chin for this motion, Your Honor, so I don't have that one in front of me.
Okay. Thank you, Mr. Garner. Mr. Pataki, anything else you want to?
Yes, just briefly. I'll start with that last issue about the texting. And Mr. Garner says that we're suggesting anytime that happens, it's an automatic new trial. We never suggested that. We're just we're asking or that you just follow the law. And the law is what it says, right? If there's a prima facie showing and there's indicia of reliability, which we believe we've done, then that's the process. From there, the burden shifts to the state, not the court, but to the state to prove beyond a reasonable doubt
that it didn't happen,
that there wasn't, that this wasn't harmful. And you start with a presumption that it was. So I'm not saying every time it's automatic. I'm saying you go through this process. So we've gone through that process. And what, at the end of it, they have failed to do anything to meet that burden. And so I understand the court's questioning about the court doing further inquiry, but I would argue that that would be helping the state with their burden under the case law. So,
I don't think that's what the case law is telling you.
well, the case law is saying it's the state's burden. So that's all I'm suggesting. We're here today for this hearing. They had opportunities to use their law enforcement powers to look into this if they cared enough to try or wanted to know the answer. They didn't. And so here we are, and that's all I'm suggesting is you follow the process, which is we believe a prima facie showing, Your Honor, is legally speaking a fairly low standard to reach, right? I mean, we use it more in the civil context, right, than we do in the criminal context, but it is a fairly low standard to reach. We've given the court evidence, and I don't know this argument that, well, it's anonymous, so therefore we can't. I mean, people typically don't assign their real name when they're, admitting that they were tampering with a jury. So it doesn't mean because it's anonymous we just ignore it. So I think to your question, I would submit that under law, especially in civil context, a prima facie showing is a very low burden. We've made that not only through the text itself, but the circumstantial indicia of reliability that I already articulated a couple of times. the process then shifts to the state. It's their burden to do and use their powers, that be, law enforcement powers, to show these things, given that it's presumptively prejudicial. So that's what I would say about that. I'm not going to go through it all. In our reply, we distinguish the cases that he brought up today, State versus Laeta, completely different situation where there was concerns about a juror's actual mental defects and ability to even understand what was going on. Completely different than this case, and all the other cases that they talk about, we've distinguished and explained why in our reply. We addressed in our reply this issue about polling. Obviously, if they did something, if there was an irregularity in the back, then they're going to confirm the irregularity in the poll, so it doesn't really get to the heart of the issue. This idea, when in their opposition they say you can consider 3 and 4, there was no caveat to it that if she meant it was at the time, or if not, then you can or you cannot. That's the first time I heard of that. Their opposition is clear. You can consider statements 3 and 4 from their affidavit. I don't know if maybe somebody else wrote this or what, but whoever wrote it believed that you can consider it. And what do you think she's talking about when she says the jury did not unanimously believe that Dr. Coney had an intent to kill his wife? Do we really think she was talking about when deliberations started and not at the end? I mean, I did not believe that he had an intent to kill his wife during the incident, and I believed that he was not guilty of attempted murder. Do we really believe that she's talking about something other than what we know she's talking about, which is during the deliberations? So, I mean, that argument should not carry much weight. Again, this thing that somehow getting this right and enforcing his constitutional rights to a unanimous jury verdict is going to have a chilling effect on jurors in the future. I don't see how that would be the case. So, one second, Your Honor. And again, I hope the court, I'm sure the court understands this. I don't know how to be more clear about it. I'm not asking you to get into the why they reached this decision, right? When the foreperson says, I did not believe he had an intent to kill, I do not believe he was not guilty. I'm not asking you to consider why she felt that way. Her deliberative process in getting to that conclusion. I'm not asking you to consider that. That's what 606 says we cannot. They wouldn't use the word processes or process if we couldn't consider the result. We polled jurors as to the result. So obviously we're allowed to ask them about the result and consider it. What would you, Your Honor, think of it this way. Think of it this way. If you polled the jury and 6 said, no, I don't think he was guilty during the poll, what would you do? You would send them back to deliberate. You wouldn't be like, okay, well, we're not going to get into your mental deliberative processes and your result, and we're going to, that's the secrecy of your deliberations, but we'll take the verdict and lock this guy up for the rest of his life. Of course not. So obviously the polling process demonstrates you can look at the objective end result and consider it. And I ask you to think about that. Those 2 examples. If you did a poll and it was not unanimous, what would you do? And if there was a verdict and a juror walked out and said to the camera, well, we found him guilty, but 6 of us really at the end thought he was not guilty, but whatever, I have a hard time believing that Your Honor or our appellate courts would just say, hey, secrecy, we don't want to, we would want to, that's up to them. No, it's not up to them. It's not up to them as to whether they follow the law or not. And so again, we're asking you to get this correct now. There is enough here to rule that way without doing inquiry or whatever. They could have done that. They have investigators. If they really wanted to do that and meet their burden, they could have gone out and talked to every single juror. They didn't. And so we're asking that you grant the motion today and set the case for our second trial. Thank you.
Counsel, I understand and appreciate the arguments that you made in this application.
application of 606B to what might have been said out into the media and what's in the moving papers that was submitted to the court. At this point in time, I am concerned about the exception to the bar that jurors can be examined on the existence of outside influence. This is brought up by the defense in the Remmer decision, and Remmer is treated, examined, and used by the Hawaii Supreme Court on this issue. Assuming the prima facie case for outside communication has been made, right, the Supreme Court of Hawaii directs the trial court by saying where the existence of an outside influence, such as juror misconduct, is brought to the attention of the trial court, the court must ascertain the extent of the influence and then in its sound discretion, take appropriate measures to assure a fair trial. This is State versus Chin, 135 Hawaii, 437, page 439. It's a 2015 case, and it cites Remmer versus United States in its reasoning. And it goes on to say that the outside influence need not touch directly on the guilt or innocence of the defendant to trigger the presumption of prejudice. It is enough that during the crucial period of jury deliberations, there was a private communication bearing even remotely on the trial or the jury's function in it. And I understand the argument as to who bears the burden and who needs to counter it, but here what the Supreme Court is telling this court that the court must ascertain the extent of the influence. So the burden is on me, right? And as abhorrent as this sounds, the way I read this case is telling me that I have to do what I really don't want to do and bring in these jurors and ask whether or not they were tainted by outside influence. And as much as I don't want to do that, the case law is must. The court must ascertain the extent.
We're going to bring the jurors in.
So, counsel, as much as you might want to rule in today, I think I have to do that. Does anybody object, or do you think I'm misreading the case?
Our position, Your Honor, is there is enough here to grant the motion. If there's enough here to grant the motion without that inquiry, because we made a prima facie showing, and the state has not met its burden to overcome the presumptive prejudice. So there's enough here. It's not for Your Honor to go through this exercise to try and save the state's, the verdict. And I mean that respectfully. So here's what I mean. I would. There's enough here to grant it. There's enough here to grant it. If you were, you can grant it without further inquiry. I don't think you can deny it without further inquiry, but you can grant it without further inquiry. And here's the problem why it should be granted without further inquiry. Here's why it should be. We're here on, what is today, August 14th?
Yes.
This motion was filed on May 15th. Okay, the trial ended, I think, in April, right? So May, June, July. Well, here we are over 4 months later.
So let me pose the question slightly differently. What if I disagree with the defendant's interpretation of 606B and the mental processes of the jury?
Then you would still grant it as to the texting issue, following the cases that we cited.
The rules say that the court must do inquiry.
Requires me, right, to ascertain the extent of influence, because just because there's contact doesn't mean that it's a bad verdict.
Well, I would disagree. That goes against the cases that we cited that suggest that any outside contact is presumptively prejudicial. So we can't ignore that. We can't ignore that. So we're not starting on even footing here. we're starting on the presumption that it's prejudicial, and that's again State versus Furutani, 76 Hawaii 172, and the point again, we would be ignoring that. And what do we do with the fact that the state has not met that burden and done anything?
Well, let's step back. If we take for face value Exhibit D, there's contact, but we don't know if there's influence, right? And
there was communication, and that's what the cases talk about. Communication with jurors are presumptively prejudicial. It doesn't say influence with jurors are presumptively prejudicial.
Look at the defendants.
And you cited, thankfully, some other cases that suggest that. We don't. It's not a harmless. Hey, what'd you guys eat for lunch in the verdict room? It's presumptive. The contact, the communication itself is presumptively prejudicial. So that's what I would say about that. And I would the other problem with what Your Honor is suggesting, which is why I'm suggesting there's enough there to just grant it now, is aside from again the uncomfortable nature of pulling these jurors back here 4 months later. I mean, I would suggest that it's probably unlikely that a juror is going to come in here under oath and admit to not following the court's rules and laws, and I was texting with them, so maybe they at that point who knows, maybe they're incriminating themselves too. So that's why there's enough here. You apply the law, which is the burden shifts to the state. The state didn't do anything to rebut it, and grant the motion. That's at least our position, because I understand Your Honor's position, but 4 months has gone by, number one. I don't,
I think the jury's going to commit perjury.
What if they're dishonest about it? As oftentimes they might be if they know they did something illegal or didn't follow the court's rules. I mean, are we giving them immunity to come in here and say, I was, so it's a little more complicated than I think simply saying 4 months later that'll cure everything, to come get 12 of them to come in here and say, oh no, we didn't communicate with anybody, there was no texting. So that's kind of what I mean, right? And the state has resources. They say it's an anonymous posting, but there's a whatever you call it, username, and I'm sure there's IP addresses and things like that the state, but they had a I forget his name, but they had a forensic IT guy testify for like a day during our trial. Maybe ask him to go look into it, right? But that's their burden, is my suggestion, Your Honor. And I understand what the court is saying, but
the IT
I just would ask the court to consider the problems with doing that.
I fully understand the problems, and that's why I'm so reluctant.
I understand.
More than reluctant.
Which is why, in a situation like this, given the time that's passed, applying the procedures that's laid out, I think that's the point, is we should avoid that exercise, and unless the state on their own had did that and provided you with evidence to overcome the presumption, then the motion should be granted, and we shouldn't engage in that process. That's at least our position. Thank you.
Mr. Gordon, do you want to be heard on that?
I'll repeat that I don't think defense has made their prima facie case. You can't make a prima facie case for a statement made by a person without identifying the person. It's as simple as that. You can't make a prima facie case that something was said without a witness, without any sort of follow-up, without anything else. Anybody can say anything they want on the internet, Your Honor.
And they do.
It is the defense's burden to make that case before any burden shifts. They did not conduct any investigation themselves. We're all in the same boat. I agree that it would be uncomfortable to bring in 12 jurors to all ask them these questions. I'm not in support of it, I guess, in that I don't think it's going to be a fun exercise for anybody. If that's court's reading of the case law is that it's necessary and required, then I won't stand in the way.
It appears that's what State v. Kim is telling us. The court must ascertain the extent of the influence.
and then, in its sound discretion, take appropriate measures to assure a fair trial. It's almost as if the requirement is not discretionary, it's just that the court must ascertain the extent of the influence.
But can I ask a question? And
Sure,
I mean
of
this. I really mean this. How do you then rectify that with the other cases that say the contact is presumptively prejudicial, right? Because I mean, so maybe I understand what you're saying, but there's other cases that say that, right? So the process that the way you're reading the Chin case is that no, we start equal and there's contact and we got to get to the bottom to see if it was prejudicial or not. But there's other cases that direct us to presume that any contact is prejudicial.
Here's my other problem, Mr. Taki. What if I don't think it's a real contact? I don't know. What if there was none? What if this blogger is just making it up?
Well, then that's why they have this procedure where all we need to do is make a prima facie case, and it's their job to prove otherwise. And again, I mean,
as much as I don't like his his style, I think defense has a good argument there.
When things are worded that way, that they're presumptively prejudicial, or there's a presumption, it means you err on the side that at the start that this was prejudicial. And you can understand why the law would develop that way. It's inherently
difficult to prove.
I mean, in this case, obviously Dr. Koenig is a doctor and he's a private attorney, but what about indigent defendants and things like that? We're supposed to go hire IT guys and investigators and track all this stuff down? No, that's why they situate it to where the burden is on the state to do those things once the prima facie showing is made. So for I would suggest that it is a low bar, as low as almost as low as I mean, if there's any anyway, it's a low bar, and I think we can turn to some language in our civil case law to help with understanding that. So anyway, and again, we come back to the problem with: are we really going to call in jurors 5 months later and ask them to come in here and essentially confess to, misconduct in open court without counsel? And when we already have essentially I know he's anonymous, but it was a written public confession that this was happening. And maybe the state should be ordered to dive in and investigate and figure out who that was. But I just the idea again, and I mean this,
it wasn't
out of respect for the jurors, to call them back in here 5 months later in a public setting and basically interrogate them as to if they committed potentially, I mean, at the very low end, misconduct, on a higher end, maybe something worse than that. I just don't see how that then becomes a reliable basis for this court to then say, well, they all said nobody did it, So there's enough here. That's why we follow the procedure. The state can prove otherwise, and if not. But anyway, that's just our thoughts on it. But,
Well, the Chin court was very clear about the language of grammar. Because it discusses grammar in the opinion. And in Chin, there's contact between a witness and a juror, established contact. Now, I don't know if that's necessarily true here, but in Chin, there's established contact. And in light of grammar, if there is a prima facie showing of misconduct, it says it required the court to ascertain the extent and effect of the improper influence. And there's a section of the opinion that talks about the court's duty to investigate. And the very first part of that section is when there is juror misconduct that presents a potential for substantial prejudice to a defendant's right to a fair trial,
There is the rebuttable presumption of prejudice, which is what you're talking about, Mr. Otake. And the trial judge is then duty bound to further investigate the totality of circumstances surrounding the outside influence to determine its impact on juror impartiality. Again, as much as I dislike it, I think I'm handcuffed as to what this particular case requires me to do. This is a Supreme Court case. It is good law, and it is binding upon me. So as much as we all object, I think this is what's required, at least of this court. The court will contact the trial judges in this case, have them come in.
Will not be streamed.
And the questioning will be conducted by the court as to, one, whether or not there was outside communication during jury deliberation. If the answer is yes, I need to probe further to ascertain the totality of circumstances of the conduct so we can determine whether or not it affected the defendant's right to an impartial jury in this case. And I understand this is the objection of both of the parties, but I think this is what is required of the court, unfortunately. So the court will make that attempt to get these jurors back.
And again, I mean this respectfully, if that was the case, we shouldn't have set this motion 3 months after it was filed, because now this case has been heavily publicized. The jurors were told that their prohibition on reading the news or looking into it ended, and who knows what they, I mean, some of them might be watching this Zoom right now, I mean, I wouldn't doubt it, right? So, I understand what your focus on the Chin case. Again, there's the Furutani case that talks about this the state's burden. So we do object to that process just from the standpoint of the delay, the exposure, and the reality of calling jurors in here in a public setting, 4 or 5 months after their verdict to now interrogate them about potential misconduct. And I think there's some legal issues about that. I mean, should they have counsel? Should they, I mean, do they have immunity from things like that? So I just placed that all on the record, but I understand the court's ruling. Whatever the court does, we ask that we expedite it. Like when this motion was filed 3 months ago, Dr. Koenig is sitting in jail. If this motion is eventually denied, we want to quickly go to sentencing. We want to appeal quickly, and we want to get back to a second trial as soon as possible because he's sitting in jail with no bail. And so whatever the court decides to do, we just ask that we do it as quickly as possible.
On that, Mr. Carter, anything else you want to add? No, we'll talk about scheduling in just a moment. Yes.
Let's see what
I don't
schedule
think we can set it next week, Council. I don't think that's enough time to contact jurors. And even if we could, whether or not it gives them time to adjust their schedule. The following week I'm in trial, so I can't do it then. But I can come back during the week of August 31st. Council, are you available?
I am not. I start a civil trial August 31st in Judge Kimara's courtroom.
He does civil and criminal.
How long is that trial going to be, Mr. Otake?
Hopefully not more than a week and a half.
What
I would say 2 weeks to be safe.
You're starting that Monday?
I believe we're starting that Monday. There was changing, there's a moving target as to what days are off, and I think the last thing I heard is we might be going every day that week, but I'm not sure. But I would, to be safe, I think it would go into the next week for sure.
Your trial?
Correct. The one that starts on the 31st.
Judges are busy. Lawyers are busy. Judges are more busy.
If I try to set it the week before, there could be a conflict with my trial. And Mr. Otake, does that prevent you from trial prep in your civil case?
I'm sorry, what was that, Your Honor?
I'm sorry.
Apologize.
If I try to set it before
the trial?
At an earlier date.
I'm in trial, but if I try to squeeze this in my trial week, I'm looking at Thursday, August 27. I think that's ambitious. But does that still out of the question because you're doing trial prep for your civil case?
Week from Thursday?
I wouldn't say it's out of the question. It's not ideal, but because we want this expedited, I'll just walk and chew gum at the same time,
There's not a lot defense has to do. The burden's on the state at this point, right? Investigation by the court.
The 25th, I cannot.
No, this would be the 27th.
27th.
The 25th, for sure, I'm picking a jury.
Got it.
Your Honor, with the 27th, I have a motion to dismiss in the afternoon, so at 1:30 p.m. Could we potentially do it in the morning?
We could.
Okay, then I should be good.
I'm sorry. I was just reminded that we actually have the hearing on the motions in limine that morning at 9 a.m. I don't believe it would go. They're not. We're limited to 5 short motions, and so the afternoon would work.
They're not available now.
Oh.
And I can't do the 28th because I already have a large evidentiary hearing.
It's the 26th, look.
The 26th, I will still be in trial.
I'm sorry, the afternoon of the 27th.
Motion to dismiss in chapter case.
Who filed the motion to
Trying to move
dismiss?
that?
If it was,
I don't know.
If it was
Your trial is all week.
prosecution, should be quick.
And into the week of the 7th.
Yes. Can I have 1 second?
You got nods from your clerk over there.
I think the last we heard from Judge Kimura is that there's no off days. So I suspect it would go into at least the first half of the week on the September 7th.
Should we select the...
September 7th is a holiday too, Judge.
It is. I'm talking later on in the week, the Friday. Can we do that?
Checking with your client's schedule.
The
He's
11th?
available.
The 11th.
He's available.
We should be done by then, Your Honor.
That's why I'm suggesting the end of the week.
That's fine with me.
Yeah.
Okay. All right.
So let's do that. Schedule for the hearing, September 11th. Council 9:30 in the morning. Appreciate your indulgence. Anything else you want to take up on the record this morning?
Yes, I would ask.
There's more?
For the opportunity to provide briefing on the process or parameters of questioning the jurors, including potentially a request to do it under seal or in camera, and if we can possibly.
I'd be for that. We don't get to see, but I think it's important to protect the jurors.
Have the opportunity to provide that briefing.
That deadline you're looking for, Mr. Otake?
Well, I would say
I want to respond.
maybe by August 28th or 21st. 1 week.
1 week from today. Submit a brief as to
Yes.
what you want included in the
Appreciate
questioning
that.
of the jurors.
Can the state respond by the 28th?
Yes, Your Honor.
Okay.
And just so I guess we have the same place to start, is the court's current intention is the court will be the only party examining the jurors.
Right, and it's on the contact.
Well, and that would be what our briefing would be about. And then just the last thing I'll add, Your Honor, I mean, I understand, not to relitigate it, but the Chin case, I believe what it was standing for is you cannot deny the motion without further inquiry. But I do believe it allows you to grant it without it. So
That's
I think that would be
the past
an
decided.
appropriate way to read Chin in conjunction with Furitani. If you're going to deny it, you need to do further inquiry. But I don't believe Chin says you can't grant it. And I think that's actually what happened in that case, is he denied the motion, and then the Supreme Court said, well, if you're going to deny it, you got to at least do some inquiry. So if you change your mind, I want to grant it, we can avoid questioning the jurors, because I think it allows that to happen without questioning
another
them.
bite at the apple.
But we do appreciate the opportunity to provide additional briefing on the process, and I think we should think long and hard about how we do that, and whether it should be in camera or what. I mean, there's a lot of issues there, and also what is told to the jury about it. And I think there should be additional questions about whether they watched this hearing today, and whether they read the motions, or what they've seen since the trial. I mean, this is just a can of worms, but we'll do our best to address that in the briefing.
Thank you. Mr. Bonner, anything else you want to add? Nothing further from me.
I guess the last thing is, I guess you're just going to reserve ruling on everything until after?
Yeah, he's not going to rule today. You've asked him.
Brought up some very good points in addition to what was already agreed. I think we should get the full record, and then the court will make its final decision.
Understood. Thank you for your time this morning.
Likewise, counsel. Thank you. Thank you for the hard work in this case.
See you on the beach. Everybody grab your surfboards. It's time well, not you, Mr. I'm sorry, sir. You get no surfboard. You get a tray through the door slot, unfortunately. All right, court's adjourned. There we go. Just your glasses, no pens. Trust me, we're going to search for those on the way out. All right, we're done. It's been a long day. It's been a long day. So defense has said there that rule on this. We want a ruling right away. And if we don't want to have this dragged out, do this right away. If you find out there's no, you find that you do this inquiry and you find nothing, no problems with it. Hurry. We want to get to that. We want to get to sentencing, get him sentenced so we can appeal, because we think we're going to get this on appeal. And they might. They had some good arguments. I'll got to give his lawyer the credit there. That was a very well thought out argument. I do see on the 606, 606B, the rule of evidence where it says that you can't ask a juror about the process of deliberation. You can't ask them about how they got to that, or what evidence, what made them swayed them one direction or another. You can't no impeachment by affidavit, and they have to focus on the objective misconduct. So it's got to be about that communication, and defense is right. You call this jury in 4 months later. Did you text somebody during this trial? If they say no, what could happen? The other person's like, actually, they did. I've got the text. They're probably friends. That's probably not going to happen. Is the court going to say, all right, turn over all your phones for a Celebrate download? Yeah, and turn over your phone records? It's not going to happen. If they say no, the problem goes away for them. And they've already, if it's happened, shown that they're willing to break the rules, because they were told not to do that, right? So you're setting up a situation where the person who was doing the wrong would most likely keep doing the wrong and deny it. That's where we've got the presumption of harm, where you just have to say it happened and then make the state flip it and put the burden back on them. Prove that it wasn't. Prove that it wasn't. You do the investigation. Do the Celebrate. Dig it up. And I think that to protect the image that we have in our minds, that our justice system is fair, that every defendant gets their fair day in court with an impartial jury, and that it's only the evidence presented at court that's going to be considered for this. I think you have to do a new trial, as much as I hate it. But I also think that if they do a new trial, the jury's going to throw the book at him. I'm surprised they didn't the first one. So it's a big risk defense is taking. Allison, thanks for all your super chats. Great ideas and great comments here. 4-person will be backpedaling faster than Mr. and Mrs. Action Class. Oh, my goodness. Good times, good times. Defense kind of won. Yeah, kind of. We'll see what happens. What is the Microsoft murder trial? That's the Jared Bradigan trial. Mario Fernandez, Shannon Gardner. That trial has seated a jury. That's going to begin next week. That trial, they've already got one co-defendant serving time for. There are 2 more co-defendants. We're going to follow the Shannon Gardner one, the third one. That was the wife of the victim. But starting on a Monday, we're following the Tupac Slayer, allegedly, trial. Dwayne Davis in Las Vegas. That's going to be kicking off Monday. The jury's been seated there as well. That's going to be an epic trial. I cannot wait for that one. So join us for that one. We'll do what we did here and make the audio as good as we can. I have to give props to Long Crime /Court TV, who is the pool camera on that feed. They have done a great job. We've got great camera angles. We've got a well-lit courtroom. We've got great audio. And I think you'll really enjoy watching the KPD trial with me. So hopefully you come back and see us on Monday. Tonight when you go home, please hug the people you love. Smile at one. Make their day just a little bit better. And please stay safe till we go live again. And it will be on Monday. We're going to do a little bit of court hopping in the morning and saying hello, singing happy birthday, all that regular stuff we do every day, because the trial being in Las Vegas doesn't start until about lunchtime. So we'll be going live about 11:30, somewhere like that. Guys, have a great weekend. Be safe. Stay healthy. May all the good things come to you. We'll see you guys. We'll see you guys on Monday. Bye-bye.
Because he's the guy.